Good morning. Welcome you all to the Citibank BIAC Inter-University International Arbitration Contest 2021, organized by Bangladesh International Arbitration Center BIAC and supported by Citibank Limited. Bonik Barta is the media partner of this event, and this program is being live streamed in BIAC and Bonik Barta's online Facebook page. Dear all, BIAC is the first and only licensed and registered alternative dispute resolution institution facilitating resolution of domestic and international commercial disputes through arbitration and mediation in Bangladesh. BIAC started its operation since April 2011. BIAC has developed all the facilities required for systematic and comfortable arbitration and mediation proceedings. BIAC has its own arbitration and mediation rules. Apart from facilitating arbitration and mediation, BIAC also provides training courses on ADR, especially arbitration, mediation, and negotiation, to develop a pool of human resource in this field. Since inception, BIAC has been working hard to create awareness about ADR methods by conducting several outreach programs, seminars, workshops, dialogues, and webinars. In 2020, BIAC added a new initiative to its activities, which is arbitration contest for university level students. Last year, we organized the first ever arbitration contest in the history of Bangladesh, which was completely conducted under digital platform due to COVID-19, with an aim of organizing this contest in the upcoming years. Keeping in mind, this year we arranged a more broad-based international contest where 2 universities from SAARC region are participating, along with 5 leading public and private universities from Bangladesh. This year, 7 leading universities from Bangladesh and SAARC countries are taking part in this contest, which are last year's champion, University of Dhaka, Bangladesh, Damodaram Sanjivayya National Law University, India, the London College of Legal Studies, LCLS South, Bangladesh, Bhuya Academy, Bangladesh, Lahore University of Management Sciences, Pakistan, Independent University, Bangladesh, and Chittagong University, Bangladesh. We distributed the 6 universities into 3 sessions of preliminary rounds. The winner of the 3 consecutive sessions will compete in the semi-final round along with the last year's champion, University of Dhaka. In each round, every team will consist of 4 to 6 students from each university. Each team will be comprised of students with the roles of coordinator, counsels, and witnesses for their respective sides. 60 minutes have been allocated for each team to present their cases. Today is the first session of the preliminary round of this contest. In the first session, we have Damodaram Sanjivayya National Law University, India as claimant and London College of Legal Studies, LCLS South as the respondent team, competing against each other. Both teams already submitted their submissions to the chairman of the session and other party. Now, we will begin with the welcome remarks from the director of BIAC. I would like to invite Mr. M.A. Akmal Hossain Azad, who has been with BIAC since September 2017 as director. Mr. Akmal Hossain Azad is a former career bureaucrat and was Additional Secretary, Ministry of Agriculture, Government of Bangladesh. He also worked for the civil judiciary for a while before joining administration. Mr. Azad studied law and public administration in the University of Dhaka and the University of Manchester, UK. He was trained on local level governance in India and on legislative drafting in Canada. Over to you, sir.
Thank you, General Manager Mahbubur Rahman. Madam Chairperson of today's session, Ms. Shehara Varia, Attorney at Law of the Supreme Court of Sri Lanka and Secretary General ICLP Arbitration Center and Director CCC ICLP ADR Center Sri Lanka. Distinguished participants, Coordinator of the Damodaram Sanjivayya National Law University, India, Mr. Pranesh Kar Rai and his team, Mr. Shah Mohammad Rafi from London College of Legal Studies South and his team, all our dear students, participants. It is my privilege to be here to listen to you and learn from your deliberations, though it is a mock sort of arbitral trial, but it will be enlightening our vision and enhance our expertise in this regard, I hope so. About BIAC, you have heard much about BIAC from our GM. I will add a few things more about our activities, but at the outset, I would like to inform you a very sad news that we lost Mr. J.L.N. Murthy, a reputed arbitrator and Secretary of International Center for Alternative Dispute Resolution, India, who just passed yesterday morning. He was supposed to chair the first session of the event yesterday morning, which had to be shifted. We pray for the salvation of the departed soul of Mr. J.L.N. Murthy. As you know, BIAC's activities are not limited in training only. It also covers arbitration, mediation, facilitation, seminars, workshops, and programs for different strata of the society, including students. During the pandemic event, we tried to keep us alive to our partners and clients by arranging online training program for students, by arranging a series of webinars in the last several months with our partners, focusing on the need and prospects of ADR in Bangladesh and the region. BIAC has passed 10 years already. In the meantime, we have some noteworthy achievements. To be humble, we need to let you know that we have been working with the government of Bangladesh, with the Bangladesh Bank, with the University Grants Commission, who looks after the curriculum of the university level students. We have also worked emphasizing on training sitting judges who come up regularly to the Judicial Administration Training Institute. We train the judges also. We had the privilege for the first time to train base level officers of the Ministry of Law. We trained them on arbitration and mediation on a day-long program. We have been mandated to carry forward helping the Ministry of Foreign Affairs in signing host country agreement with the Permanent Court of Arbitration. So these are a few activities of us. We don't boast. We are on the halfway of our journey, not yet a fully grown up entity because of time and other resource limitations. We're trying hard to let people know that Bangladesh can be a seat of arbitration, and we're trying to let others be acclimatized with our activities so that we can build up BIAC as the regional hub of ADR with the cooperation of all our partners here, including the community of lawyers, arbitrators, ADR specialists, academicians, and students as well. I welcome the students for participating to this session and wish both the teams all the best. Though one will lose and one will win, we look forward to all of them for their future prosperity and future professional life. I had a personal acquaintance with one of the 17 national law universities of India, that is Gujarat National Law University, where we had a training program in 2020. It is my personal privilege to be acquainted with the Damodaram Sanjivayya National Law University based in Visakhapatnam, Andhra Pradesh, I think. But I am very happy that the team comprises people from Vasco da Gama to Kolkata, from Patna to Faizabad. India is a vast country, and I am very grateful to the team manager and all the students that you have built up a very broad-based, geographically broad-based area representing many parts of India. We look forward to hear from you. And from the London College of Legal Studies South, they are a partner organization of us. They were in the first session of the first ever inter-university arbitration contest, which was limited on domestic spectrum only last year. They were there. This time I welcome them for the second time in the same type of, though on broader base this time, contest. I wish both the teams all the best. Thank you for listening to me. We go to the session. Thank you very much.
Thank you, sir, for your nice words. May I now introduce our today's chairperson of the session. We are extremely honored to have with us Ms. Shehara Varia, who is the Director of Ceylon Chamber of Commerce ICLP ADR Center, Sri Lanka, and Secretary General of ICLP Arbitration Center. She is an attorney of law of Supreme Court of Sri Lanka. She is a fellow of Chartered Institute of Arbitrators, UK, and director of CIRB Sri Lanka. She is also an accredited mediator of London School of Mediation. She is the partner with FJ and G. Saram. Now it is time to start the contest, and I would like to hand over the stage to the chairperson of the session to start and run the contest. Best of luck to both the teams. Over to you, madam.
Thank you very much, Mahaba. Thank you very much, Mr. Azad, for the nice introduction. And I must thank BIAC for giving me this opportunity to sit in as arbitrator in this contest. I have seen the work of both teams, and I think it's very commendable. They have put in a lot of time and effort. And I must say, it's even the request and the response is even better than what you would see in a normal arbitration, in an actual arbitration. So I congratulate both teams on the effort you have put into the detail. And it was a very pleasant read for me. And this is the first step that any counsel or arbitrator must do to relay the case very clearly. And even the responding counsel, and I think that has been done very well. So I'm honored to preside in this arbitration, and I wish both of you all the very best for the rest of the competition. So I think the teams have been introduced, and the arbitration is between Shapa and founding partners and IDG Capital Limited. I assume you have all been given the time allocation that has been put before you. I will also be keeping time, and I might interrupt you from time to time if I have any questions or if there's something unclear. So pardon me for that if you're midway of your argument and I disturb you. So please proceed. May I now invite the claimant to make its opening statement, and you will be given 10 minutes from now.
Madam, before which, can you not introduce each one by their names or ask them to introduce themselves?
Yes, please do. So may I ask the chair?
May I have the floor?
Yes, please.
Thank you, Madam Chairperson. Good morning, everybody present here. Honorable Chairwoman, members of the tribunal, and everybody present here. A very good morning to you. I am the coordinator of the team representing the claimants, ShopUp, a startup company, and the founding partners, a group of young tech entrepreneurs. In this mock arbitration between the claimants and IDG Capital Limited, the respondents, we have 6 members in our team. As counsels, we have Nandini Verma, Shashank Mohan, and Siddharth Nayak. As witnesses, we have Jashashri Mishra, in the role of Ms. Roshni Bose, who is the Chief Executive Officer of ShopUp, and myself, Pranesh Kaur Roy, in the role of Mr. Viraj Narang, who is the Chief Operations Officer and Chief Technical Officer of ShopUp. The oral submissions will be initiated by Ms. Nandini Verma, who will be delivering the opening statement, which will be followed by the direct examination of our first witness, Ms. Roshni Bose, by counsel Mr. Shashank Mohan. Later on, our second witness, Mr. Viraj Narang, will be directly examined by counsel Mr. Shashank Mohan. Both the witnesses of the respondents, Dr. Kauser Williams, who is the Executive Director at KW Financial Analysts Incorporated, and Mr. John Snow, who is the Chief Executive Officer, will be cross-examined by our counsel, Mr. Siddharth Nayak. The closing statement will be delivered by our counsel, Ms. Anushka Sikarwal. Throughout this session, I shall be moderating for my team. If this honorable tribunal is well introduced to my team, may I please yield the floor to Ms. Nandini Verma to deliver her opening statement.
Sorry, in the meantime, LCLS South may introduce themselves. Please.
Right.
With the permission of the chair.
Thank you, Akmal sir, for the floor. Greetings to everyone, Arbitral Tribunal, as well as my learned friends from the claimant side. My name is Shah Mahmoud Rafi. In this session, I shall be the coordinator from the respondent side, IDG Capital, and I shall also be the counsel, one of the counsels. From our side, there will be 4 counsels. Fardin Fayaz, Karzan Siddiqui, Maimuna Chaudhuri Raya, and I shall be the counsel for the respondent side, IDG Capital. Fardin Fayaz will be responsible for delivering the opening statement. Karzan Siddiqui will conduct the chief examination, followed as and Raya Chaudhuri shall be giving the doing the cross examination, and I shall be giving the closing statement. Amar Amit Bukhari shall play the role play of Dr. Kauser Williams, and Nazif Ali shall play the role of John Snow, the CEO of IDG Capital. With that, I hope it is clear to everyone what the roles of every member of a team are. And without further ado, I'd like to give the floor to my learned friends from the claimant side.
Thank you. Now I request Madam Varia to take the floor and conduct the session. Thank you.
Thank you very much for the introductions. Now the claimant may commence its opening statement.
Good morning, Honorable Madam Chairwoman. I am Nandini Verma, the counsel representing the claimant in this proceeding, that is ShopUp and the founding partners. The claimants have approached this tribunal under Article 20 of the Shareholders Agreement. The counsel seeks permission to proceed further. ShopUp is a startup founded in 2016 with a share capital of 4 million euros in Bangladesh. The app unifies all the customers' ShopUp cards through which one could enjoy discounts on products. Our client sought a business angel for the beta version of the app in 2017. By business angel, we mean an investor who shall provide additional funding, a pathway to international market, and valuable inputs for the app. The reason we collaborated with IDG is because IDG is an established joint stock, a high-tech company with the necessary consolidated experience, and it offered to invest 4 million euros and offered the critical mass by providing the distribution of the ShopUp app across Asia, which would guarantee the sustainability of the company. IDG Capital offered a consolidated place for all of their needs, and hence they entered into an agreement in which IDG Capital would invest 4 million euros for 40% of the share capital of ShopUp, of which they merely invested half the promised amount, and all the hefty planning of increasing the revenue up to 1,076,172 euros by 2020 and expanding it in the markets of Asia was nothing but hollow promises, as they focus solely on one online clothing store. Valis and converted ShopUp into an ad hoc app designed exclusively to meet the online store's specific needs. Moreover, ShopUp was renamed as Valis Deals even after making 33 plus modifications. IDG, at the behest of Valis, always asked for more and more modifications. All these would have been worth it if the revenues had shot up to the estimations made in the business plan, but it was a mere 40% of the estimations. On expressing concerns about the revenues and IDG still not signing the distribution agreement, the founding partners only received suggestions on further modifications, but not a sign on the distribution agreement, which should have been signed latest by 20th August 2017. The app was just one of the many ventures for the joint stock company, but it was a brainchild of a group of creative computer engineers. When they witnessed the utter failure of the app because of the so-called business angel, they decided to start a new entity from scratch. Omega is a lifetime experience app for user, as it offers hands-on control over all the phases and a renewed payment gateway and many new features such as interactions with other users to exchange reward points from different stores. As soon as the app was launched on Google Play Store in December 2018, IDG Capital started making baseless acquisitions against the founding partners. They alleged that the claimants were using their know-how and putting their own startup ShopUp out of business, and the claimants were dealing in bad faith. The claimants would still want further clarifications as to how a lifetime experience app, which was made from scratch, used the know-how gathered from an utterly unsuccessful online clothing store. The very fact that IDG stopped the investments and unilaterally terminated the contract put ShopUp out of business, not a completely different app, and thereby IDG Capital fundamentally breached the 15th clause of the shareholders' agreement. The allegations of the founding partners dealing in bad faith was nothing more than an unsuccessful attempt by IDG Capital to lift the cap fixed on liability of 4 million euros as given in the 16th clause of the shareholders' agreement. This substantiates that all those allegations by IDG have neither any factual nor legal support and are solely a diversion to avoid their capital contribution obligation. As has been cleared above, the two apps were very different and not at all in competition with one another. Therefore, the claimants did not breach the non-compete clause of the shareholders' agreement. The success of the Omega app is not only demonstrated by the unique features offered by the app, but also the fact that the app became a big hit within 2 months of it being launched. In comparison, the ShopUp app, with all the so-called inputs and know-how of IDG, was not able to reach even 50% of the estimations made in the business plan even after 2 years. Further, going by the principle of exception non-ademptity contractors, the founding partners were exempted from abiding by the non-compete clause, that is the 11th clause of the shareholders' agreement, as IDG failed to meet the target sales as contemplated in the business plan. And as an implicit responsibility, they were the first party to oblige and perform the contract. In the case of Klockner Industry versus United Republic of Cameroon, during the course of execution of work, the respondent alleged failure of the claimant to reach milestones and deducted the 6th and 7th payments, while the tribunal characterized it as a suspension of performance as the claimants had no other choice. Similarly, in the present case, the performance was suspended by IDG Capital and they committed a breach of their own obligation. ShopUp went out of business just because IDG stopped the funding towards which it had an obligation, hence causing the founding partners a lot of losses. The claimants are in no way liable and do not have any reason to compensate IDG, as they had not been able to prove the link between the success of Omega and ShopUp's failure. IDG's rule of the first player in the network economies is their usual exaggeration, like the promises made in the business plan and the allegations, as there are many other sectors with apps based on network economies which thrive because of healthy competition between players. Food Panda and Uber Eats being one of the many examples. The council would also like to highlight that the respondents have made contradiction in their own argument. Their first argument states non-performance and breach of obligations. They have falsely accused the claimants, whereas their second argument states that the non-performance was conducted due to a triggered action of the claimants. It is hereby implied that they themselves aren't clear and are indeed acknowledging the fact that the non-performance happened from their side. The International Arbitration Court of the Chamber of Commerce and Industry of the Russian Federation in a dispute between a Russian company and an American company, where one of the parties restrained from further negotiations and all of a sudden terminated the contract, the tribunal held that the party should have informed the respondent of its intentions. In the case of Joseph Charles Lindmeyer versus Ukraine, the International Center for Settlement of Investment Disputes referred to 4.1 and 4.3 article of the Unidroit Principles 2016, which talks about interpreting the agreement in accordance with the common intention of the parties, and argued that in addition to the obligations expressly mentioned in the agreement, prior negotiations between the parties has to be emphasized. In this instant case, along with the expressly agreed obligations, the orally agreed obligations during the prior negotiations had been recorded in the agreement. According to the fact sheet, the respondent orally expressed its obligation to provide an optimal marketing strategy that would guarantee the sustainability of the ShopUp app and insisted on having control over the timing and area of distribution of the app. Taking up another argument about gross disparity, as stated in the case of Coda versus Carnival Corp, there is a provision to exclude terms if there had been a gross disparity in understanding the contract. The claimants, as per the Unidroit principles, would exclude the individual term, that is the sellout clause, the 15.2 clause of the shareholders agreement, as that particular clause in the entire contract gives them an excessive advantage, and due to the occurrence of gross disparity, which is them taking unfair advantage, the claimants have faced hardships due to economic distress and their misconduct throughout the fulfillment of obligations in the contract. Referring to the case of Singh versus Carnival Corporation, in the light of the facts presented, both the presuppositions by the tribunal in the cited case entirely match the situation in the present case. There is a serious disparity between the parties' reciprocal rights and obligations, as the respondents did not perform their obligations, which gave them an excessive advantage as they are yet to pay their installments, and this led to economic distress, which was unjust. In the present case, the respondents were due to pay 2 million euros out of the 4 million euros as capital funding to ShopUp, according to the shareholders' agreement. Since the abrupt non-performance of the shareholders' agreement by the respondents have not paid the said amount to ShopUp for the last 2 years. Even further, upon non-performance of the shareholders' agreement, the respondents inevitably caused ShopUp greater harm, as a company cannot run without funds, and ShopUp was not breaking even, as not even 50% of the revenues projected in the business plans were met. The claimant has, as a direct result of the respondent's action and non-performance of the contract, sustained significant harm. The claimants were guaranteed successful distribution of the app in the Asian markets, but even after 4 years, only 40% of the targets set in the business plan had been met. As a consequence of this, the claimants have also been deprived of any gain that might have been possible had the respondents performed the contract to satisfaction. Claimants would like to humbly contend that we are clearly entitled to additional damages. Since the additional damages are not expressly mentioned in the agreement, the claimants sincerely prays to this tribunal to find that claimants have suffered additional damages as per Article 7.4.3 of the Unidroit Principles, which reads, when the amount of damages cannot be established with a sufficient degree of certainty, the assessment is at the discretion of the court. Honorable Madam Chairperson, This concludes an introduction from my part. And if you have any further queries, our submissions will now be issued through the direct examination of our witnesses and thereafter cross-examination of the witnesses of the respondents. And at the end, through the submissions and legal arguments, where we will further establish the remedies that we will be claiming from this honorable tribunal against the respondents.
Thank you. I just need one, I want to ask you one question. Based on the shareholders agreement and the fundamental breach clause which you are claiming, and the fact that you are of the view that the claimant had the right to breach the non-compete clause because there was a fundamental breach. Is that your position, or on what grounds does the claim?
Sorry, the council would humbly like to disagree with the madam. The thing is, the claimants have not breached any clause of the shareholders agreement.
No, it's not the claimant. I'm talking about the respondent. So you are making the contention that the respondent has breached the agreement. There's a fundamental breach as per the legal statement made by you. On that grounds, the claimant was able to go against the non-compete clause in the shareholder agreement, or what is your, I couldn't follow that statement made by you a little earlier on in your opening statement.
Yes, ma'am. The respondents have clearly breached the shareholders agreement as they stopped the funding, and it was a unilateral termination, which furthermore breaches the clause 15th of the shareholders agreement. Since they did not perform their part of the contract, so going by the principle of exception non-contemplative addendus, the claimants had the opportunity of not performing their end of the bargain as well.
Understand your conclusion.
Okay.
So the app was developed after there was in fact the non-contribution to the capital, or in between that period?
No, ma'am. The app was developed in 2018, and the claimant stopped funding they usually make the funds in January. So when the app was launched in the markets in December 2018, the funding was stopped from the next month or so.
So the funding was stopped after the app was actually launched?
Yes, ma'am.
Understood. Thank you. Thank you very much.
Thank you.
May I now request the respondent to make its opening statement?
Thank you.
Madam, if I may just intervene a bit, I think the claimant is supposed to do the chief examination now, and then we will conduct the cross-examination. I think that is
yes, madam. I think as per the schedule, you may please give the floor to the claimant for their direct and redirected examination of witness, if I'm right.
I understood that each part is to give each one's opening statement.
Thing is, the claimant team will take 1 hour sequentially for the first statement, then the examination, then cross, then arguments, then come. Then the
it's not across, is it? Okay, then because I was under the impression that each party will be given 10 minutes, then the other party the 10 minutes.
That will be at the third phase after the direct examination of witnesses by the claimant. Cross-examination of 2 witnesses will be done by the respondent.
Okay. Sorry, I understood that it's going to be parallel, so that it's not against the other. That's fine. Please proceed.
In the second session, it will be the reverse.
Please proceed.
Am I audible and visible to the tribunal?
Yes, yes.
Thank you. Good morning to all of you. Honorable Chairwoman, I am the Chief Examination from the claimant side, Mr. Shashank Mohan. Without further ado, I would seek the permission of this honorable tribunal to invite our first witness, Ms. Roshni Bose, for direct examination. May I have the permission?
Yes, please proceed.
Much obliged. May I have the first witness, Ms. Roshni Bose?
Good morning. Yes.
Yeah. Good morning, Ms. Roshni Bose. Thank you for appearing before this honorable tribunal.
Thank you for having me.
Yeah. So, please state your name and designation for the record.
I'm Roshni Bose and I'm the CEO of the company.
Okay. Could you please enlighten to the honorable tribunal about the role in your company?
My responsibility is to look after the working of the company, basically.
Okay. So, Ms. Roshni Bose, were you the CEO when the contract was signed between IDG Capital and the founding partners and ShopUp?
Yes, I was the CEO and the contract was signed between IDG Capital and the shopper.
Okay. Moving forward, Ms. Roshni Bose, as CEO, would you take us through the composition, nature, and ambit of your company?
Yes. The composition is basically computer engineers. They are the computer engineers, the founding partners. The nature of the company is it works in the sector of development and marketing of software in Bangladesh and in India, and intends to extend its activities across Asia. And the ambit is, yes, it presently works in Bangladesh and India and hoping to extend, hopes to.
Nice. So, Ms. Roshni Bose, tell us briefly about the ShopUp app which you people have developed.
Yes, so ShopUp was basically founded in 2016 by computer engineers, who are basically the founding partners. It operates in the sector of development and marketing in Bangladesh and in India. It has its one-star product, the ShopUp app.
Okay. So, Ms. Roshni Bose, why at all did ShopUp want to collaborate with IDG Capital despite there being other market strategists and investors?
First things first, what are the other investors you're talking about? We were just seeking for an established company. We're searching for someone who could invest in us, and we thought IDG Capital to be worthy of it. Unfortunately, they eventually proved that they weren't worthy as of now, but yeah.
Yeah, so we will discuss that further. Okay, moving on, Ms. Roshni, did you ever go through negotiations prior to the signing of the agreement between IDG Capital and the founding partners?
Yes, we went through prior negotiations before the signing of the contract between IDG and Shop.
Okay, given that fact, I would like to ask you a follow-up question. Kindly take us through those negotiations. What were those negotiations and how you reacted?
Before IDG and ShopUp signed the contract, the prior negotiations were that IDG insisted on having control over the location and timings. Secondly, they offered us 4 million euros to invest in return of 40% of the share capital. And they promised us to boost our distribution and sales in the market.
Okay. So you are quite clear on that aspect.
Yes, very clear.
Okay. Moving forward, what was the approach of IDG Capital? I'm talking about specific approaches. So what was the approach of IDG Capital towards the commercialization of the ShopUp app?
Okay. IDG Capital, the approach of commercialization was basically the idea was to have sales in the Asian markets. We never had any expertise over the commercialization marketing, and the reason we approached them, the IDG was supposed to do this for us.
Okay. Nice. So moving ahead, how did that approach worked out for you? Was it good? Was it bad? So according to you, how did that approach worked out?
Obviously bad. They promised us that they would develop the sales and distribution. They would spread our activities across the Asia, but eventually we end up in having an ad hoc app in the same platform for one online shop. The value is there. And second thing was there was 40% profit, which we received at the end of the year 2018. which were decided in the estimated business plan, the projected ones.
Okay, so you did possess a business plan,
Yes.
and there were annual targets as well.
Yes.
Okay. So moving ahead, once you were aware of the technical modifications wanted by Valis, what was your next course of action?
Very simply, when IDG informed us the technical modifications, we implemented them as per them.
Okay. So this particular answer lets me to another question. Did Valis ever directly contact you regarding the technical modifications?
No, we were communicated by IDG. Valis never communicated to us directly.
So you were never directly communicated by Valis. You only got the information through IDG Capital. Okay, correct. So what were the technical modifications, Ms. Roshni Bose, all about? And IDG Capital did specifically told about that? What were the technical modifications, basically?
The IDG Capital informed us that it was all regarding the payment gateway, all that we know about those technical modifications.
You were informed about the technical modification as far as the payment gateway is concerned.
Yes.
Okay. Moving forward, Ms. Roshni Bose, could you please shed some light on the newly developed Omega app, which is in turn very controversial in this particular aspect?
Sure. So Omega, we launched Omega in December 2018. It was a lifestyle app, which had this another motto to make our lives easier. The features were to book hotels, to reserve flights, and to check those status wherever we are in. And it had another feature of rewards point, basically.
Okay. So moving forward, did you receive any technical know-how in order to develop the Omega app from IDG Capital?
No, we didn't. We didn't receive any technical know-hows.
Okay. You didn't receive any technical know-how as far as development of the Omega app is concerned. Is it correct?
Absolutely not. Yes.
Okay. Last question from you, Ms. Roshni Bose. Would you consider Omega app and ShopUp as competing products?
No, not as competing products.
Okay. Thank you. Thank you, Ms. Roshni Bose. Madam Chairwoman, if you have any questions with the witness, you may ask, please.
Just as to whether the investment required by IDG was only for the app that you have entered into, or as a general shareholder in terms of your investment in your company?
It is specifically for the IDG.
Did you have any reporting requirements if you were doing any competing products or similar products? Was in the negotiations, was there any discussion on the ability to develop non-competitive but similar products?
We discussed about not developing any similar sort of products, and we would stick to awards that ShopUp and Omega are two different products, entirely different products.
So have you ever discussed the features of Omega with IDG?
We never felt obligated to discuss because we were completely aware that that was in software development app and this was in lifestyle app.
And you didn't require any investment for that app, or you had a separate investor?
We had separate investors for that app.
So you didn't consider it prudent to check with IDG whether they would be interested in investing in this app as well?
Basically, we weren't satisfied. By June 2018, we were only getting 40% of the profit. So we knew that we shouldn't approach them anyway. We never approached them.
But from your opening statement, the app was developed prior to the third installment required, right? They did just from my understanding, the two installments had already been made, and the Omega app was developed during that time, while those two during the investment period.
Yes. After the second installment, basically we are waiting that how would our shop up function, and will their technical modifications, whichever they recommended us, will make us any gain in the market. But that ended up with mere 40% of whatever we projected into. So this gave us, we were actually frustrated. We even gave them suggestion that we could launch it in Middle East markets, but they denied our suggestion. So we basically thought of developing another app to somehow sustain there, as in to gain profits. And we asked different investors.
That was after they had defaulted.
Madam Chairwoman, may I interrupt? I want to give a slight clarification because there is a confusion as far as the launch of the Omega app and ShopUp app is concerned. So what the opening statement said that the Omega app was launched in 2018, December 1. The ShopUp app and the investment regarding that particular app was made in 2017 only. The two investments of 1 million euros respectively for 2 years were made for the development of ShopUp app and not the Omega app.
I understand that very clearly, but there are claims for breach of non-competition, etc. So I'm trying to understand. In order to decide on those claims, I need to understand the facts surrounding those two. Only because there is an allegation. If not, I wouldn't be interested in when the app was developed or its features. But since there is an allegation and request that there is a breach of the non-competition clause and a fundamental breach of the agreement itself, is why I want to understand whether the respondent was aware of the Omega app and whether the breach of the installments was after that. And from what I understand from both the opening statement and the witnesses' evidence, is that the Omega app was developed prior to the breach of alleged breach of the installments being made by the respondent. So that's why I want to understand when the claimant did decide. I mean, it's up to the facts as to whether the app is in high competition or whether there's an actual breach of the non-competition clause. It's too early to decide for that. But what I want to understand is whether the claimant, from what I have understood currently, the claimant commenced the Omega app before the breach of the installment payments.
No, may I clarify, Madam Chairperson? So the breach which we are claiming that they have non-performed their part is for the development of ShopUp app.
I do understand that, but that's a breach of non-competition. So in order to understand the non-competition, I need to understand when that non-breach occurred, if at all. I'm not saying it occurred.
It is prior to the launch of Omega app.
That's correct. Yes, that's what I want to do.
Thank you. Thank you very much.
So
ma'am,
I really wanted to ask the CEO just before the next as to whether you had, because the breach is very clear that the non-performance is after the app was actually delivered. So given that they were partner in another app, I do understand that they are two separate products. Did you have any discussion with them on investing in that app as well? Or was it a total surprise to them when this app was developed, the Omega app was developed?
Madam, they are the two different entities. So we basically had this continual contract with IDG Capital for Shopper from the year 2017 basically, and we developed Omega in 2018 with different investors. So we never discussed this with IDG Capital, but we considered them as different legal entities having different functions, target audiences. We never actually felt obligated
They're just
to
an
do
investor,
so.
right? They are an investor. So they would invest in any app, as I would understand. So I just wanted to understand the relationship, but that's fine. I will stop with that because I'm wasting my time. So please proceed.
So Madam Varia, now it may be the turn of the respondent to cross-examine. You may instruct accordingly.
Am I audible?
Can you please repeat?
Am I audible?
Yeah, you're audible.
Thank you. I am Maimuna Chaudhary, counsel on behalf of the respondents. With the permission of the Honorable Arbitrator, I would like to cross-examine Ms. Roshni Bose. Thank you. Ms. Bose, the only agreement that was signed between ShopUp and IDG was a shareholders agreement, wasn't it?
Yes.
If my respected colleague would bring up the slide. As per the agreement, prior to the launch of Omega app, IDG had always paid their installments on time, didn't they?
Yes.
But what you were dissatisfied with was the marketing and distributive obligations of IDG, weren't you?
Yes, we were satisfied.
Because instead of marketing and distributing, what they were doing was constantly giving you modifications for the app, especially particularly about the payment getaway system, isn't it?
Particularly from Valis.
If I am correct, your collaboration with Valley's deals ended when the Black Friday sales of 2017 occurred, isn't it?
Could you please repeat? I wasn't able to hear you completely.
According to the timeline, by Black Friday of 2017, the collaboration that ShopUp app had with Valley's had ended, hadn't it?
It was supposed to end there.
So all the technical modifications that took place in 2018 had nothing to do with Valley's, didn't it?
I would repeat, it was supposed to do that, to end there at 2017, but all that in 2018 continued from the Valis only.
Okay. And all these modifications were specifically to the payment gateway system, isn't it?
Yes, IDG informed us so.
Ms. Bose, ShopUp is an app that unifies discounts to its customers, isn't it?
Yes.
If the payment system is flawed, the discount itself becomes useless, doesn't it?
But it's not only the payment gateway. We were approaching for commercialization, and commercialization is a different aspect.
Ms. Bose, we're talking about the app itself. If the app doesn't have a good payment system that the client can use, then the discount, which is a feature that the app provides, that itself becomes useless, doesn't it?
I would not consider it only the discount or payment gateway system can attract clients that way.
If a consumer cannot use the app as it is supposed to be used, which is the discount system, because of the payment getaway system, if the sales decrease because of that, that is not the fault. You cannot say that it is a fault of the marketing or the distributive nature of the partner of IDG, can you?
Even it was so that the payment gateway was something not perfect in the place. We worked with your modifications. We implemented them according to you.
Yes, and according to that, there was a lot of modifications made, so much so that the whole of ShopUp app was revamped into Valley's deals, wasn't it?
Yes, as an ad hoc app.
Yes, and through that ad hoc app, you obtained all of Valley's online clientele, did you not?
Could you please repeat?
If Valley's had used your Valley's Deals app for its clients, then you had obtained all its online clientele, hadn't you?
Obtained all clients? We do not think so.
All their online clients.
All the online clients, we do not think so, because what we receive is mere 40% profit of the estimated business plan. So if we're talking about getting all the clients, we could have received and gotten more profit, right?
Yes, but then we also have established that the modifications were not complete, hadn't we?
So you cannot really possess a question, right? Saying we got all their online clients.
Yes, but moving on, at the end of the day, it's about the distribution that you are discontent with, isn't it?
Distribution, development, and obviously we weren't satisfied about the profit sales.
However, none of the specifics of how to do that and when to do that was materialized in form of a contract, was it?
We were inexperienced in that particular aspect, and that was the reason we approached IDG.
So, as per the shareholders agreement, which is the only agreement that you have signed between IDG and ShopUp, like IDG had performed all of their contractual obligations under that app. Wouldn't you agree?
Absolutely not. They hadn't performed their contractual obligations. They haven't fulfilled all the contractual obligations. They have promised us to boost our development sales or distribution sales, but they didn't.
Yes, Ms. Bose. By September 2018, agreeing with you, ShopUp had no increase in sales, isn't it?
Yeah. Yes.
It was at this time that the ShopUp's developers started working on Omega, isn't it?
Because we had to sustain anyhow in the market.
Yes, this was around the same time they were working on ShopUp's modifications, wasn't it?
We worked in third quarter of 2017, and the Omega was developed in the December and launched in December.
Yes, but in 2018, you were also working on ShopUp's modifications, weren't you?
We were working on ShopUp's modifications in third quarter of 2017.
As well as 2018, as per the given facts, Ms. Bose. The modifications were, as we have established before, the modifications was regarding the payment gateway system. Interestingly enough, Ms. Bose, Omega app does not have that problem because you have reformulated the online gateway system, isn't it?
Omega has better features, and that is the reason that feature is actually getting concealed with that particular thing.
Ms. Bose, we're talking about that particular feature only, the payment gateway system. Could you answer that?
It can be better directed to the second bit.
Okay. Interestingly enough, ShopUp as a group of developers had the know-how on how to reformulate the entirety of the payment gateway system. In any time whatsoever, you hadn't informed this to your investors, IDG, isn't it?
One thing, I would request you to direct all the questions regarding payment gateway to our technical head, that is the second witness. He could answer better way.
I see. Okay, then. You chose, so Valley's Deals, would you say it's a completely different app to what ShopUp was intended to be?
Yes.
So Omega was also an app that was completely different than ShopUp, correct?
Yes.
So you could have launched Omega under ShopUp as you did with Valleys, isn't it?
We never launched Vallis. Vallis happened due to the modifications, and it was an eventual process that we developed an ad hoc app. But we are not satisfied with the profits, and Omega has a different intent, different product. It wasn't restricted to just being there in the Asian market. It had different target audience.
Ms. Bose, Valley's Deals was launched at the end of 2017 by Black Friday sales. You are aware of that, aren't you?
We are aware of it, but we never intended to launch Valley's Deals.
Thank you. You would say that Omega app has a feature that unifies the discounts and rewards offered by different stores under one platform for the customers, doesn't it?
Omega app had the feature of providing discounts to the customers for tracking. A lot of apps have the particular feature, and this is nothing very new or something special to only ShopUp or Omega.
But ShopUp itself was created for that very purpose, wasn't it? To unify discounts given by different stores and restaurants under a single app, wasn't it?
Exactly. ShopUp was restricted for collecting cards and giving up discounts, whereas Omega had a larger ambit, had a different target audience and essential features.
So Ms. Bose, that one feature of Omega app directly targets the same consumer audience as the entirety of ShopUp app, doesn't it?
I would like to repeat my statement. A lot of apps to attract clients to customers have this reward features, and this is nothing new or specific to only ShopUp that we developed in Omega.
Yes, Ms. Bose. According to your own expert evaluator, Alina Blake, as to her paragraph number 6, She states directly that, excuse me, let me take you to that paragraph. Here she says that ShopUp now competes in the market with the well-established Omega. That is the statement given by your own expert evaluator.
Okay, I would like to answer this. ShopUp competes in the well-established market and Omega. Does it say that ShopUp and Omega are competing with each other? They are in the same market, doesn't indicate they're competing products.
All right, Ms. Bose. Omega app had garnered success by February of 2019, wouldn't you agree?
Yes.
However, IDG had given you the notice that it wished to terminate the contract on 2nd of December, the very next day after the launch of Omega app, isn't it?
Not a notice of termination. We had an exchange of emails which said that they were disappointed, and we also said we also provided our stand. There was no notice of termination.
Ms. Bose, if I can take you to that email.
Yeah.
I interrupt you to be conscious of the time taken.
Okay.
And also
Apologies.
the election of the Respondents' Council as in to understand as to whether the questions are from various aspects. Can we have some direction on the specific?
Yes, ma'am. Madam, 11 minutes, 30 seconds has been used. For cross-examination, we have an allocated time of 15 minutes from both sides, both for the claimants and for the respondents. So Maimuna Choudhury still has about 3 minutes, 20 seconds to finish her cross.
But they have another witness.
It's 2 witnesses and the time has to be divided.
Maimuna Choudhury to answer that.
Honorable Arbitrator, I'm almost done with this line of questioning. If I may begin?
Yes.
Okay. If I can take you to the email states that while dealing with us can only result in the dissolution of our partnership. That is, wouldn't you say that is like a statement of termination of contract, Ms. Bose?
Could you please take me to that particular email and line? I need to see.
Okay. Case facts, paragraph number 21.
Oh, no, it's just presenting, right? And also, can you repeat the question?
Just a second. In paragraph number 21, it says that your manifest bad faith can only result in the dissolution of our partnership. This is a clear statement of termination, isn't it?
This is a clear statement saying that we are not interested in continuing the contract. Does it say that we are terminating on proper grounds?
Yes, Ms. Bose. Supposing that the termination took place on the date of this email, IDG wouldn't have anything to do with ShopUp after 2nd of December, would it?
Considering this as termination, yeah,
yes,
you would not have anything to do with ShopUp after this.
Okay, no further questions. Thank you.
Thank you.
I understand the claimant as another witness.
Yes, Ms. Chairperson. So may I proceed with the examination of my second witness?
Please.
May I call upon Mr. Viraj Narang?
Am I audible?
Yeah, you're audible and visible.
Thank you.
So, good afternoon, Mr. Viraj. Thank you for appearing before this honorable tribunal.
Good afternoon.
To begin with, please state your name and designation for the record.
Right. My name is Viraj Narang, and I'm the Chief Operations Officer as well as the Chief Technical Officer of ShopUp.
Thank you so much. Moving forward, could you please enlighten the Honorable Tribunal about the role in your company?
I oversee the day-to-day operations as well as the technical aspects of app development. So my role includes any and every change made to the app, and without my sign-off, a technical change cannot be made.
Right. So, were you the CTO and COO when the contract was signed?
Yes, that is correct.
Okay. Would you please elaborate on the payment gateway issue, which is again a very controversial issue?
Right. Yeah. It seems like this is the only point that's been revolving around and around in this hearing. So from the time ShopUp started receiving requests for technical changes in the app, a very common theme in the requests remained a supposed issue with the payment gateway. Right. So in my opinion, since Valiz is the only company which has been using our platform for online retail, the 40% return recorded is solely from Valiz selling their merchandise online. The payment gateway seems to work just fine. I think it's IDG's shortfalling in their marketing strategies, which has brought our company to its knees.
Okay, nice. So moving forward, Mr. Narang, would you say that you received any technical know-how from the IDG Capital, given the fact that you are the CTO of this company and you are operating all along? So did you ever receive the technical know-how?
That's a very interesting question. Thank you for that question. IDG Capital is an investment company which has signed a deal with our company for distribution in the Asian market, right? So any and every form of technical know-how required to make my app is absolutely copyrighted by us. And IDG Capital has no access or expertise in the matter. So I would say that we have received zero technical know-how from IDG Capital.
Correct. So you are convinced and you believe in this?
Absolutely. There's no way IDG Capital has given us technical know-how.
Exactly. So moving forward, Mr. Narang, since you are the CTO, how would you project that ShopUp app and Omega app aren't the competing products?
Right. This also seems to be a very important question. So ShopUp, let me say this in very simple terms, right? So ShopUp unifies loyalty cards on a digital platform. Okay. And Omega, on the other hand, is a lifestyle app which has a reward system. Okay. So these two products are different and have no link with each other technically or market-wise, right? Let's talk about Omega for 1 second. When we are talking about reward system, there are a lot of other apps which also have reward system. Let's take, for example, Rapido. I came to this arbitration on a Rapido using my rewards from my yesterday's ride, right? And we are not suing Rapido. So I don't see the problem.
Yeah, correct. As you are the Chief Operational Officer also, so in that particular designation, would you enlighten the tribunal about the annual target sales projected by the business plan according to the shareholder agreement?
Right. I have the figures in front of me. It's 5,51,000 euro as of 2017 and 6,88,750 euro as of 2018.
Okay. So did IDG met those annual targets?
No, absolutely not.
Okay. So do you consider that they lagged in the commercialization of the product just because they are saying that the payment gateway issue and for that reason only they failed to meet the annual targets?
Look, since I am the technical officer, this app, the entire coding and everything, the development, I have done it. All right. So I have my footprints and handprints all over the app. And as far as I am concerned, the payment gateway works just fine. All right. So yeah, I would say that the payment gateway is not an issue.
Correct. That's a good statement. So moving forward, what was the capital contribution? Like how much have already been paid?
Right. The capital contribution as per the...
I'm sorry to interrupt, but given that we have limited time, can we not refer to figures that are already provided?
Okay.
For example,
Sure.
capital contribution, the amounts paid are already provided. On the
Yes,
technical
Madam Chairperson.
question, is there a claim that technical expertise is to be provided? Is there some, I haven't seen it anywhere in the documents as to whether there's a requirement to provide technical expertise.
Ma'am, I didn't get your question.
Given that there was a question as to whether technical expertise was provided by the respondent and it was not provided, you answered that it was not. Is there a requirement to provide in any of the arrangements that have been entered into with the respondent?
Ma'am, not exactly, but what we firstly wanted from the respondents was the market distribution strategy
That's
and
right.
the
That's what
distribution
I
in the Asian
understood.
market. Yes, ma'am.
Correct. So
But
that's
that
so let's not
that
waste time on questions that don't relate to that.
ma'am, I'd like to add just one more sentence to the answer to your question. Ma'am, since we have gone through more than 33 technical modifications, a little bit of technical know-how, like the design of the app, the design that they wanted has been communicated to us, but it has been designed on a digital platform by us. So the technical know-how is totally ours. It's copyrighted. But the requests have been coming right from day one.
Request
From IDG Capital.
the request, sorry, the request for what?
For technical improvements.
So you
and the
have
payment
asked
gateway.
them for it, is it?
Yes, ma'am. IDG Capital has asked us to do technical improvements. Valis has asked through them.
But the investments were not related to such expertise or provision of that sort of feedback to you.
Yes, ma'am.
Did they have a say in terms of the agreement? Do they have a say as to whether technical expertise should be included as and when they ask for it?
No, ma'am. We did not have that conversation.
So may I proceed, ma'am, for further 2 questions only?
Yes, please limit the time and also not documents you already have.
Definitely. So, Mr. Narang, what is your opinion on the non-signing of the distribution agreement?
The distribution agreement is the heart of this entire matter, right? So IDG Capital accused us of acting in bad faith. We believe that the non-signing of the distribution agreement, a document upon which our entire negotiation was based, is an explicit display of disrespect and inherent bad faith.
Correct. My last question to you, Mr. Narang. What was your response when IDG Capital failed to meet the annual targets for 2 consecutive years, that is 2017 and 18?
Right. To be very frank with you, we were dejected that our brainchild couldn't take off and fly simply because IDG Capital did not do their job properly. They haven't signed the distribution agreement till date, and that gave us an impetus to suggest that they explore the Middle Eastern market. Not only did they ignore that advice, when Omega app was launched, they simply sent an email to us stating that we have acted in bad faith and that this should result in the termination of the contract. And we, of course, believe in good business ethics, wrote back and requested that they perform their part of the contract, as Omega app was not a competing product to ShopUp app, as we have been repeating from day one. IDG Capital did not deign to reply and hasn't paid the rest of the installments amounting to 2 million euro yet.
Okay. So at this point, I would like to stop the questioning. So I would like to give the floor to the respondents, if at all they have the time to cross-examine.
With the permission of the Honorable Arbitrator, I would like to cross-examine Mr. Narang. Mr. Narang, I'll keep this very short. I'll only ask you 4 questions. Is that okay with you?
Yeah, that's completely fine. Thank you.
Fine. Mr. Narang, interestingly enough, you say that the payment gateway system of ShopUp was completely fine. However, for the new Omega app, you've completely reformulated the payment gateway system, didn't you?
Yes.
As a developer,
I haven't, to add to the answer, I didn't completely reformulate the payment gateway system. It's almost the same. Plus, that's
improvements, isn't
copyrighted
it?
technology, so I cannot talk about it here.
All right. If you had the technical know-how of how to develop or improve upon such a payment gateway system, did you at any point, you didn't at any point convey this technical know-how to your investors, isn't it?
I'm not obligated to pass on any kind of technical know-how to the investors.
Right. In your statements, you have said that there are other apps operating in the market who have similar features, but you are not suing them, isn't it? However, Mr. Narang, you do not have a non-compete clause with those apps now, do you?
Correct.
Okay. If we look at the non-compete clause in the shareholders agreement, it states that not only directly, you cannot even indirectly provide any services whatsoever to an app that can compete against ShopUp app, correct?
Thank you for that question. I have not provided my service directly or indirectly to any competing product. These two apps are not competing products.
All right, no further questions, Mr. Narang.
Thank you.
If I'm correct, I think we proceed to the opening statement of the respondent.
Greetings to the respected arbitrator. I'd like to introduce myself as the first counsel on behalf of our clients, IDG Limited, who have appeared as the respondents in the present case of arbitration. The counsel would speak for 15 minutes regarding the detailed discussion of the three substantive issues. As the facts are already known to everyone present today, the counsel believes that a general overview is not necessary. So if it may please your excellency, the counsel would like to proceed to the substantive issues with your permission. Respected arbitrator, Benjamin Franklin once said that when will mankind be convinced and agree to settle their difficulties by arbitration? With regards to that, we contend that even though our client IDG Limited have agreed to the present case of arbitration by upholding Franklin's very principle, we aim to achieve our best interests, as the whole purpose of arbitration is to fulfill the interests of both the parties. Moving on to the three major issues, the first of which we contend is that the claimants have breached the fundamental obligation of abiding by the non-compete clause. The legal analysis of the breach of the non-compete clause would further be divided into two sub-issues. Ma'am, the non-compete clause, which is clause 15 of the shareholders agreement, stipulates that founding partners cannot render services for any competing organization, with particular emphasis on the word competing organization. Now, if they actually collaborate with the competing organization, what follows is that our client, IDG Limited, receives the right to terminate the contract, since their collaboration would amount to a non-performance of the contract as per the Unidroit Principles 2016, which, by the way, is the authority which governs the rules of the contract. Now, speaking of non-performance and its link to a breach of contract, a layman's interpretation would generally refer to a situation where there is a failure of performance without a lawful excuse, entitling the other contracting party the right to an appropriate remedy. Performance of the contract meant that founding partners merely had the task of not developing a competing app or to provide services for a company which is in direct competition with our client IDG Limited. However, it is very unfortunate that the founding partners completely went beyond the agreed principles, as their collaboration and association with the Omega App Limited, another app which directly competes with the ShopUp app. Madam, to justify the argument that such a direct competition exists, the counsel would like to state that the ShopUp app's unique selling point, as in the differentiating feature of a business, was that it would be offering attractive discounts to its customers through their affiliation with retail shops, stores, and restaurants. This, as we know, is the same feature that the Omega app comprises. In relation to that, let's look at the example of two major tech companies operating in the same country as ShopUp. Uber Limited app, the worldwide renowned known app, offers ride-sharing services to its users and is said to be directly competing with the local app in Bangladesh, Pathao Limited, another app which also offers the same service and which is also arguably their best and most popular feature, even though they offer a range of other services as well. Moreover, the fact that the reward scheme is an ancillary feature which Omega claims cannot be taken into consideration, since the aforementioned feature boasts the requisite qualities to generate revenue which surpasses that of our client, entailing another reason why direct competition exists. And lastly, perhaps the most crucial evidence which strongly backs up the proposition that ShopUp and Omega are in direct competition is seen in the expert report issued by Dr. Elena Blake, where she expressly stated that ShopUp competes in the same market as the well-established Omega. Moving on to the second substantive issue, which is that the claimant does not have the defense of exceptio non adimpleti contractus. I'd like to shed light on what is exactly the exceptio defense. Madam, this is the kind of defense that can be raised, and if in fact raised, it allows a party to withhold his own performance until the other has duly performed his or her obligations under the contract, thus making them immune from the non-performance claims. For anyone to avail this defense, they must establish 4 requirements that must be met in order for the exceptio defense to apply. First, being that the two performances are centered around the principle of reciprocity. Secondly, non-performance. Thirdly, the other party must be obliged to perform first. And the last requirement is that the non-performance must not be triggered, caused, or connected by the act itself or the party that invokes the exception. In light of these 4 requirements, I'm going to shed some light as to how the claimants cannot successfully avail this defense. In relation to the first requirement, which is the reciprocity principle, the obligations of the the contracting parties must be under the same mutually binding legal relationship. However, when we speak of reciprocity and a legal relation, it is to be noted that as per the facts, it cannot be stated with sufficient clarity that whether there was in fact a legal framework that had actually existed between the parties, since the distribution agreement was never signed. The second requirement is that there must be a non-performance, and even a partial one, but significant enough of the other co-contractor. As the council already spoke about non-performance, there would not be any further analysis regarding this sub-issue. The third requirement is that the other party must be obliged to perform first, meaning whoever is bound by a mutual contract may refuse to perform his part until the other party has performed their part, only if the latter party is bound to perform his first. In plain, simple words, it must be expressly or impliedly written in the contract that IDG Limited should be the one to perform the contract first. Now, as we know, as per the shareholders' agreement, there is no such indication. Rather, the contract expressed simultaneous obligations, and thus, clearly, ShopUp fails in this regard. Moving on, the most important requirement which the council believes, and we humbly submit, is that this might be the most influential factor in this case, is that the non-performance must not be triggered, caused, or connected by the act itself or the party that invokes the exception, as the facts clearly stipulate or solidify that ShopUp tried to market a beta version with the help of IDG Limited. Now, beta is just a test version of an app, and it is not a clear example of the way a proper app with appropriate functions that can be marketed. Now, despite this, IDG Limited provided all the inputs about the app to ShopUp, and there is proper evidence that the claimant's beta version had too many faults, and IDG Limited kept giving the inputs that some feature of the app needed to be changed, especially the online payment gateway offered by ShopUp app, which constitutes a hurdle when it comes to finalizing the payments with the major retail stores. Now, logically speaking, IDG Limited cannot market such a faulty app throughout the Asian market, and hence they asked ShopUp app to improve their technical modifications. Now, it was clear up to ShopUp to fix this, but instead of fixing this, the founding partners opened a different company altogether and made a new app which clearly shows their malicious intent. The council would refer to the case of Kolar versus Khan Industries Limited, where the claimants and the respondents entered into an agreement regarding the sale of plumbing products. Unfortunately, the products were not of market value. And later, the respondents did not fulfill the promise of giving commission to the employees of Kolar, who was involved in the distribution of the products in the market on behalf of the respondent. Now, Khan Industries, during the court proceedings, tried to invoke this defense by saying that they did not fulfill their promise first, and hence there should be no more shipment of the products. The court rejected this argument and took the side of the respondent. Khan Industries could not pay the commission to the employees since they could not market the plumbing products due to its defects and hence suffered loss. The situation of this current case is very much similar to the aforementioned case of the Kolar case. If ShopUp had produced such a marketable product, clearly IDG could have fulfilled its obligation and thus reached the agreed sales amount. Hence, ShopUp should not be given the benefit of using this defense where the claimant itself is at fault for not making a proper app despite receiving so many inputs from our client IDG Limited. And finally, which is the last issue, where the claimant acted in bad faith in their dealings with the respondent, Honorable Arbitrator, we'd like to contend that any contract, whether a simple one or an international commercial contract, is built on the notion of good faith. Good faith is a broad concept that refers to an honest conviction or purpose that is free of malice or the desire to cheat individuals. The principle of good faith, therefore, as the ICJ case in Nicaragua versus Honduras has observed that one of the basic principle governing the creation and performance of legal obligation is not itself a source of obligation where none would otherwise exist. And any contract, whether a simple one or an international commercial contract, is, as we know, is built on the notion of good faith. The principle of good faith, as the ICJ stated that one of the basic principles governing the creation and performance of legal obligation is not itself a source of obligation where none would otherwise exist. The question then becomes, did the claimant uphold this duty incumbent on them? The fact that the claimants never informed the respondents that they took the initiative to develop a parallel competing app not only breaches a fundamental obligation, but also indicates the bad faith of the claimants. We'd further like to contend that the claimant took advantage of the technical input provided by the respondent. Since the claimants used the technical input provided by the respondent to develop the Omega app. As per Forbes Asia report in April 2019, which stated that Omega is the dominant app for discounts with stores and restaurants and hotels. It had also had a renewed online payment gateway, and these are the exact same features that are present in our clients in the claimant's ShopUp app. This indicates that using the very input provided by IDG Limited, the claimants were able to build a competing app that essentially put ShopUp out of business. This is clear from the disparity between the valuation of ShopUp, which was approximately 7.5 million euros based on Dr. Kauser's report, and the valuation of Omega, which was a astonishing 150 million euros. And going behind the back of the respondent and taking advantage of their technical input, the claimants have demonstrated bad faith in their dealings. And with that, the council would like to rest their submission if the honorable arbitrator has no further questions, and pass the floor to the chief examiner and the witness. Thank you.
Just one question. Did you consider the fact that, I mean, your investment is in the company itself and it's not tagged to any benefit of a particular app? So have you all considered that by the claimant developing a different app, it would bring further value to the company? Because from what I read of the shareholder agreement, the non-competition clause is limited to the fact of the goodwill of the company as it exists on the closing day. So have you considered whether a development of a parallel app, whether in competition or not, of that you already have invested for, would bring benefit in raising the goodwill of the claimant?
Thank you for the question, honorable arbitrator. I'd like to submit that there is also a non-compete clause in the shareholders agreement, which is for both the parties to abide by, that that founding partners cannot render services for any competing organizations, meaning that if there is any breach on part of them, we receive the right to terminate the contract and thus either buy their shares or sell our shares at a either sell our shares at a high price or buy their shares at a discounted price. That was the whole agreement that was done between our clients and the founding partners. If I was clear, respected arbitrator,
No, it is clear, but I only want to know whether you have considered the fact that it would have increased the goodwill of the claimant company which you have invested in, if that was a successful app.
I'm sorry, respected arbitrator, I could not comprehend your question.
Okay. Now, perhaps it's for the witness then who is involved in the company, as to whether the in the non-competition clause, as I read it, seeks to keep the goodwill of the company as at the date of the investment. So I only want to know whether you had considered, whether the respondent had considered as to whether the claimant developing a different app, which you claim is in breach and all of that. I understand your points there. But did you ever consider that that app would have also increased the goodwill of the company that you have invested in? The fact that they have two products as against one.
Yes, we do consider that, but what the council was referring to is rather this goes against the very principles of the contract that was established between founding partners and IDG Limited. So if they are to develop a competing if they are to develop services for a competing organization, this puts us in an unfavorable position, since this is something that we could not comprehend. This is the whole reason why we put a non-compete clause in the shareholders agreement. So if they are to offer the ancillary features in the Omega app, which, by the way, generated sufficient revenue for them and took them to an astonishing value of 150 million euros valuation. My whole question is that they could have instead informed our client that, these are the services or these are the modifications that we aim to bring, and we could actually work together, and there was no need to develop an overall new app instead. So, ma'am, I hope I was clear to answer your question.
You can proceed.
Madam, the opening statement's time is over. If the counsel is finished with his arguments, we would like to proceed with the chief examination of the first witness of the respondent side.
Am I audible? All right.
Yes, you are audible.
Good morning, Honorable Arbitrator and my learned friends. My name is Mohammad Akhtar Zaman Siddiq, and I am the counsel for the respondent IDG Capital Limited. I shall be conducting the chief examination of our witness. With the permission of the Honorable Arbitrator, may I please proceed with our first witness? Thank you. Could the witness please state their name for the record?
Hello, I'm John Snow.
Mr. John Snow, what is your profession?
I'm the CEO of IDG Capital Limited.
Mr. Snow, what's your relation with the claimant?
Well, the Claimant ShopUp is a startup company who developed an app called ShopUp app, with whom we came to an agreement where we would act as an investor as well as help them in advertisement.
Mr. Snow, what is the nature of agreement did you reach with the claimant?
Well, we were to invest 4 million euros in 4 installments in return for a 40% stake in the company's stock. Additionally, we had further responsibilities of making use of our Asian distribution network in order to aid ShopUp to create a foundation for the company's sustainability. However, the exact details of the distribution was never settled.
Could you please elaborate on the installments?
Yes, sure. The agreement with the founding members constituted that the capital was to be paid in 4 installments. The first one being on 17 June 2017. Secondly, 1st January 2018. The next one on 1st January 2019. Lastly, it would be on 1st June 2020. We made the first 2 contributions as per the stated dates.
Mr. John Snow, why was the distribution agreement not settled as you mentioned earlier?
Well, for us to distribute with the best advertising strategy, from our expertise and market research, it was imperative that the timing and location of the distribution can be controlled.
Why did you want to have the control?
Well, ShopUp's novel features such as it is a smartphone app that unifies all customers' ShopUp cards through which he or she can enjoy discounts by companies as a marketing strategy to ensure the customer's loyalty. As you know, discounts are best utilized when the timing and location is right, such as before an event to have the most impact.
Then did you follow through your strategy of further distribution, Mr. Snow?
Well, we were working with the founding partners in order to set up the legal framework regarding the distribution agreement, which was supposed to be finalized by 20th August 2017. However, it was never signed, therefore never executed. Nevertheless, we did take definite steps to distribute the ShopUp app by bringing many parties who were interested for the founding partners to give the necessary boost to their project.
Could you please tell us more about the interested parties?
Sure. Well, in 2017, we were approached by many retail stores interested in working with ShopUp. We basically focused on the one of the major ones, namely Valleys.
Why did you focus on Valleys?
Well, while the other stores were interested, they were not as confident in the app as Valleys due to the technical problems underlying in the software. Valleys did that collaboration and gave ShopUp their necessary feedback about the state of the app and how to improve it. We would use that information later to pander to other clients.
Mr. Snow, how then do you deal with the problem of the technical problems?
Well, we passed to ShopUp, the numerous technical modifications to the beta version of the ShopUp app required by the interested store. Consequently, funding partners made more than 33 modifications to the app and succeeded in satisfying client by making a different app under ShopUp, namely Valley's Deals. However, that was done specifically for Valley's, the collaboration with whom ended by Black Friday 2017. But the underlying technical problems with the software, including the payment gateway system, was never fixed.
Why wasn't the payment gateway system fixed properly, Mr. Snow?
I don't know actually why they did not resolve this issue, because development is not our expertise. However, we kept them up to date about the technical improvements required for commercialization in our emails. We also provided them with the statistics and information gained throughout 2017 from offering the ShopUp app through our Asian network and conducting additional in-depth marketing studies. ShopUp works exclusively on these modifications throughout 2018 based on our service, but the main issue was yet to be resolved.
Then what did you do next?
Before we could do anything, it is clear that the online payment gateway system provided by the ShopUp app represented a significant barrier when it came to finalizing agreements with major retail stores. The app will be perceived as more appealing to our potential customers if they could improve this technical aspect, and we would have been able to achieve our goals if they would have done so.
Was that the last discussion you had regarding the topic?
Not really. Okay, not really. Though we emailed about them about the issue, the app was not properly functioning despite the year-long efforts. The marketing of the app was depending on its development when it came to finalizing agreements with major retail stores. While we understood that they were putting in an effort, it could not be denied that the fact that a proper functioning app was necessary for the proper advertisement of it. So hence we could have taken no further actions other than helping them through the utilization of our Asian network. The founding partners were not happy about it.
Could you please elaborate on how the founding partners were not happy about it?
Well, they emailed us and said they were worried that we were not making reasonable efforts to market the shop as per the representations and commitments made by us. But that was entirely wrong.
Why was it wrong?
Well, it is obvious that since we held a stake in the company, it would not make sense that we did not put in our efforts. No investor would act in such a manner that would result to their own loss. Marketing or commercializing a faulty app is a problematic feature within itself.
What did IDG do after getting that email from the founding partners, Mr. Snow?
Well, we wrote them back, clarifying our confidence in them, securing potential clients despite not meeting the estimated sales. However, the clients would not be secured until all technical issues with the application have been resolved, namely the payment gateway system. We explained this was based on the technical input gathered from our network for over a year now in order to ensure that the app is compatible with the clients and the ShopUp can tailor the app to meet the specific needs of each client's business.
What happened after that, Mrs. Snow?
The next thing we get to know is that there's a new app on the Play Store called Omega app developed by the founding partners, which was very similar to ShopUp in the features it provided. This was a clear breach of the non-compete clause 11.1a. Enraged, we sent them a notice of termination of contract through an email and stopped all contract.
Could you please elaborate on why you believe the non-compete clause was breached?
Sure. As per the clause, they were not allowed to provide any services directly or indirectly to a competing organization. During the time of our collaboration, it was apparent that Omega was basically a similar app like ShopUp, which engaged in direct competition and breached the non-compete clause of the agreement. Furthermore, in the time that they secretly created Omega app simultaneously with the technical modifications of the ShopUp app, they could have easily made those additional changes to the existing app instead of creating a whole new company. Thus, we believe that as of the end of 2018, ShopUp and the founding partners had abandoned the app completely, hence setting it up for the failure.
Then
here again, I have a question. This is the question I've been trying to ask from both parties, from both sides, and I have still not got a very clear answer. Does your investment in the entity was not for a particular app. Yes, you did agree to do certain things in addition to distribute this app, etc. But the value that you would get in the company would be a company as a whole. I don't see any particular profits related to ShopUp only in this agreement, unless I have missed something which I could have. So please let me know as to why would you consider another app. I mean, the fact that it's a competitive app is a different story altogether, but as to why would you consider this new app being not giving you value for your investment? Because the investment appears to be in the company and on the company's profit. So if Omega gave the company profits, you would still be entitled to it as a shareholder, is what I have understood, unless I have got it wrong. So can you just explain to me as to why whether that has been considered?
Ma'am, can I answer that question?
Yes, my question was to you as a CEO.
Okay, ma'am, thank you. Actually, Omega app was based on the ShopUp's features, and it was made by the developers of the ShopUp and the founding partners, though, but it was under the Omega Limited, a different company, which we think is a direct competition with our app, our organization, because we were investing in ShopUp, not Omega. So when they actually created the app Omega, it was not in our hold. It was of a different company, and the sales which were accrued from the Omega app was none of our concern. It surpassed ShopUp. Yes, ma'am.
I don't want to take too much time. I understood. That's what I wanted to understand.
Yes, ma'am. Thank you.
There's a relation to that company.
Honorable Arbitrator, I just have one last question. Mr. Johnson, now what happens that the claimant have breached the agreement?
Well, finally, we held that they had violated the non-compete clause in the shareholders agreement, and because of the breach was of such a fundamental nature that the contract can no longer be fulfilled. Hence, no further payments were made as of the date of the termination. Furthermore, the buyout provision of clause 15 of the agreement would be triggered.
Thank you. No further questions.
Thank you.
The respondent counsels may continue with their cross-examination. John Snow.
Thank you, Mr. Afisha Mohammed.
Chairperson, I have an objection to the last question that was asked by the counsel. May I raise it?
Would you raise it as a cross-examination, or you want to raise it as separate objection?
Ma'am, objection for the last question by respondents' counsel to their own witness.
See?
Ma'am, the counsel has assumed that we have fundamentally breached the contract, and I would like to object to that.
Understood. So you have to prove otherwise in cross-examination.
Yes, ma'am. We will be proving further. Thank you, ma'am.
Yes. Thank you, Mr. Naran, for the objection raised. Very good morning, Madam Chairperson. This is Siddharth Kumar Nayak. I'm the claimant's cross-examination, and I would like to call upon Mr. John Snow for the cross-examination. Yes. Very good morning, Mr. John Snow.
Yes, good morning to you too.
Yes. Please state your name and your role at IDG.
I am John Snow. I'm the CEO of IDG Capital Limited.
Okay, thank you. When the founding partners were looking for a business angel, we came to you. We found the IDG Capital. Is that right?
Yes.
And the primary duty which was given to you was to invest in our ShopUp app, 4 million euros.
Yes.
Yes. And your job was basically to distribute and distribute and commercialize the app, right?
Well, it was not stated. It was stated in the distribution agreement, which IDG and ShopUp didn't sign.
Because you insisted just in your direct examination that you were holding the expertise in that area. That's why you didn't want to sign it.
Expertise in which area?
In distribution of this, because you wanted, which area to launch the app for.
No, actually, I stated, I'm rephrasing this now. I stated that development is not our expertise.
Okay. So distribution and commercialization of the app.
I didn't either. I neither said this. I said that development is not our expertise. We invested it. We invested in ShopUp app.
You invested it.
Yes.
Yes, I'm concurring the fact that you invested in it. I'm asking it, you were responsible for distributing the app in all across the globe, in the Asian market and etc. Is that right?
We were actually in terms for investing it and distributing across the Asian network.
Yes, correct. Thank you very much. So can you please name a few other major retail, like the other retailers which you spoke about, which were not interested in ShopUp app, and you went with the Valleys company?
We went with the Valleys, yes, because they were very much interested rather than the other companies.
And if I'm correct, you stated that the other smaller retail store were not interested in ShopUp app because they already had seen the underlying problems. Is that right?
Not really, as they were not interested as much as Valleys.
Okay, Valleys, fine. So now that we have chosen as Valleys as the main partner, the biggest partner, and that we were going to go with Valleys for the ShopUp app. Now that from the 2017, from the timeline of 2017, you made the first capital contribution, second capital contribution, the underlying profit was 40%, right? We were only getting 40% return.
Firstly 50%, then 40%. Yes.
Firstly 50%, 40%, right? So now you see that the entire timeline you kept us giving modifications, and what Valleys was giving problems, like Valleys tell ki this is the problem, that is the problem, so many number of problems that accumulating up to a number of 33 problems, right?
Yes.
And we gave 33 modifications, and that was all those problems were resolved.
Not really. The payment gateway system was yet to be resolved.
Payment gateway. I'm talking about the Valleys Deals app. The Valleys Deals app was all the 33 modifications solved the problems with Valleys Deals app, and the app was launched perfectly by 2018 Black Friday. Is that right?
But it was not mentioned that the payment gateway system is resolved or not. It was not mentioned. Yes.
Let's say that you made us the founding partners when we were working on ShopUp app. Suddenly this Valleys deal came in, and we were totally engrossed in this Valleys deal because all this time we were focusing on Valleys thing, and that we totally forgot the ShopUp was the initial thing. We came to the IDG Capital with ShopUp app. By 2018 Black Friday, that became into Valleys deals. So I think our resources, our efforts were directed into something else, and Valleys deals became something else. It became totally about of Valleys. Isn't that right?
Well, Valleys, the first term of our agreement was to distribute the app, right? Distribute the app, right? And through our Asian network, Valleys, the company, was also our concern, was also a step of ours to distribute and advertise the app. It was ShopUp's good, the ShopUp's advantage that Valleys deals have suggested the certain modifications.
Sure. But right. Now, yes.
Because we were the investors. We did not know what the technical modifications would have been done to the ShopUp app. Valleys suggested those modifications. We couldn't. So you have to think that Valleys actually, Valleys actually made an advantage for the ShopUp. Actually
made an advantage, but 33 modifications were made, and we solved all the problems of Valleys deals, and we gave it to them by 2018 Black Friday, right?
Black Friday 2017, maybe
28. 1 second. Black Friday,
because in December 2018 Omega app was launched.
Yes. Apologies.
Thank you.
So 2018. Okay, no issues. I was just clarified. Sorry for the delay, the mistake. So now we can say that we constantly hear from you that you do not know any technical know-how, right, about the applications and everything.
Well, from the outer sense, I know the technical problems, but I actually don't know the hard coding behind it.
But you know the overall problem, overall thing.
Yes.
Okay.
Yes.
So now, if I say that Valleys deals and Omega are the same app, will you agree with that?
Yes.
But we explicitly stated in our mail to you after you on the 2nd December, when you sent us a mail that you sent us a mail on 2nd December that we are, since you have launched this Omega app, we are dissoluting this contract immediately because you have breached the fundamental
Yes, clause 11.
Clause 11. Yes, yes. So now I'm asking is when we responded on 7th December stating that we were surprised, the founding partners respond to you that we were surprised by this and that the Omega and ShopUp are totally different apps.
Yes, the dispute is about that ShopUp is not considering the fact that ShopUp app and Omega is direct competitors. We are actually, it is very much apparent that ShopUp app and Omega are direct competitors. And by the clause, by clause 11 of the shareholders agreement, we are by the clause 11.1a, it is explicitly stated that if any of the parties help in directly or indirectly to a competing organization, we have the right to actually terminate the contract.
Terminate contract in spite of the founding partners who are actually the developers who know the inside out of the program. They have explicitly stated that these two are completely different apps. Even after that, you wanted to terminate the the contract.
Because we had the necessary statistics. If you go through the case facts, there is explicit, there is a statement explicitly saying regarding the statistic that Omega was the most prevalent and dominant app throughout the Bangladesh, which were famous about for their discount offerings.
How many? Yes, yes. Continue, please.
Yes. So ShopUp's this was actually ShopUp's main feature, which was Omega's ancillary feature, but surpassed Omega. But sorry, ShopUp.
Yes, yes. But this Omega app was launched only in Bangladesh. That's right.
Yes.
And this Valleys Deals was an Asian market. That was a much bigger market.
Valleys Deals or ShopUp?
ShopUp and Valleys Deals, both of them. Let's forget Valleys Deals for now. Let's focus on ShopUp. Valleys is past now. ShopUp was in the bigger Asian market. Right?
Well, in Asian market, yes.
Okay, Asian market, fine. So now when you say that ShopUp has started from 2017 until 2018 and all that, it has almost more than a year. Can we agree with that?
More than just more than a year, yes.
Just more than a year. And how many months do you think ShopUp, this Omega app has been launched? 4 months?
Just a month. It was actually launched in December 2018, and the statistics was around
April 2019.
April 2019, is that correct? April 2019, the statement
Forbes.
that Omega was actually dominating the market.
Forbes magazine gave an estimation of this Omega app in April 2019, stating that it's 150 million euros. Right?
150 million, yes. 150 million euros.
Yes. So how can you say that this is prevalent? Like, because when you say about well established, how do you think just because an app has shot to 150 million euros, it is well established, whereas a company which has, or an app which has which is in the market for more than a span of 1 year is not well established?
I'm not saying that Omega app established. I'm just saying that it surpassed the sales of the ShopUp app, which through the ancillary feature. Through the ancillary feature, which is a direct competition with ShopUp.
Fine. Okay. So can you tell us the reasons as to which, when we replied to your mail stating that you wanted to terminate, that was not a termination notice. That was like we wanted to dissolute the contract. You did not sit down for further negotiations.
Well, I did not. We do not have the this is not actually flexibility. Actually, we don't have the flexibility, because there is clearly mentioned in the shareholders agreement, which states that we can terminate the contract. The non-breaching party can terminate the contract right away without further negotiations, right?
Yes, but you said in 2nd December that we are immediately stopping will make no further contributions, capital contributions. Isn't that a fundamental breach? Because
no. Firstly, they ShopUp breached the contract by breaching the non-compete clause. They breached, we terminated.
you claim that we, the founding partners, have breached it, and you are the non-breaching party.
Yes.
Yes, but what my
because there has to be a contract to breach it. So if the contract is breached already, how can we how is a contract there even to breach it?
Right, fine. Right. Yes. No further questions, Madam Chairperson.
Thank you.
Would the respondent have any other witnesses?
Am I audible? Yes, Honorable Arbitrator, we have another witness. May I please proceed with that?
Madam, before we begin, the claimants took 12 minutes and 25 seconds in their cross-examination. So they have about 2.5 minutes to finish their if they do their cross-examination of the second witness. Only 2 minutes.
2 minutes, 25 seconds?
25 seconds, 30 seconds, yeah.
2 minutes, 30 seconds. Thank you very much, sir.
Could the second witness please state their name for the record?
Hello, my name is Dr. Kausa Williams.
And what's your occupation?
I'm an executive director for KW Financial Analysts.
And what exactly does your job entails? Dr. Williams.
I usually give financial advice and to financial and commercial advices to different companies and individuals, especially on calculation of loss of profit claims and some restrictive trade practices.
And how are you related to this BIAC case number 2, Dr. Williams?
Well, I have been contacted by IDG Limited to issue a financial report.
For what reason did IDG require your expertise?
Well, they asked me to firstly to calculate the actual fair market value of ShopUp. And secondly, they also asked me to calculate the loss suffered by IDG due to ShopUp breaching the non-complete clause.
Dr. Williams, to calculate the actual fair market value of ShopUp, what resources, if any at all, did you use?
Oh, I use the resources pretty efficiently. I used the documents and information that were available in front of me. And I also adopted some assumptions.
Dr. Williams, what documents did you use?
Most important was the business plan attached to the shareholders agreement. Then there was the ShopUp's financial statements between the years 2017 to 2020. I also looked upon some industrial reports, and the instructing lawyers were there to give me an overall background of the case.
Dr. Williams, what are the assumptions you made?
Well, my first assumption was based on the geographical location. I assumed that ShopUp operated in Singapore, Thailand, and Sri Lanka, but not in other parts of Bangladesh, India, or Pakistan. The reason behind it is the consumer habits in those areas are very much similar to those in Singapore, Thailand, and Sri Lanka. And my second assumption was based that the operating costs reduced substantially each year. And my last assumptions was I took a steady growth rate of 4%. And most importantly, the discount rate in this calculation was 8%.
Using the said documents and the said assumptions, how did you calculate the fair market value of ShopUp?
Well, I use an economic method that is widely recognized around by many experts. This is known as the DCF, or the discounted cash flow. So what it actually does, it calculates the cash flows of the company over a projected length of time and calculates the net present value of each cash flow using the discount rate.
So, Dr. Williams, in your expert opinion, what is the as-is fair market valuation of ShopUp?
Well, after I've calculated it, I'm pretty sure about my calculations. It is euro 7,410,647. That's the fair market value.
Dr. Williams, can you clarify again what was your second objective required by IDG?
Oh, as I have repeated, as I've said before, it was to calculate the loss suffered.
Loss suffered. What considerations did you take into account to calculate the losses suffered?
I took two considerations. The first one was the value of IDGs as is share, and the second was the value of IDG shares under a but-for scenario.
What is the value of IDGs as is share?
If I recall, it is euro 1,852,662.
And what are the but-for scenarios that you mentioned?
Oh, interesting. This but-for scenarios, there are two types of two different scenarios. The first one is where Omega app existed, and the second one is where Omega app didn't exist. These are the two but-for scenarios.
Dr. Williams, what is the valuation shop up in the but-for scenario where Omega app did exist and was a successful app?
Well, in that case, it is euro 53 million.
And how did you come to that number?
Well, I have to estimate Shopup's cash flow following the implementation of the business plan that I projected from 2021 to 2024. Then I also incorporated future cash flows resulting from the development of Shopup in new areas. That's how I did it.
So Dr. Williams, then what would be the valuation shop up in the but-for scenario where Omega app did not exist?
Well, in that case, it is 100 million.
And how did you come to that conclusion?
Well, that's interesting. So in that case, I took an comparator. It was the Omega app. So I valued Omega app at 150 million euros. So Omega app was competing with Shopup, and it had wide features, like more features than Shopup, and hence and much more better. That's why I discounted this euro 150 million and I got euro 100 million. That's how I did.
Dr. Williams, you estimated two but-for scenarios. What was the reason for that?
Well, in this business world with so much uncertainties, you need to make sure that you are safe. So I did to improve my accuracy, calculate two but-for scenarios, and I made an average out of this two.
So Dr. Williams, what would be the value of Shopup had there been no breach of the non-compete clause? That is, what is the actual value of Shopup in your but-for scenario?
Oh, that's euro 76 million.
What is the IDG share valuation in that but-for scenario then?
Since IDG was supposed to have 40% stake in that company, so the IDG share value would be euro 30,657,6,587. That's the value.
Then Dr. Williams, what is the damage that IDG has suffered? What is the losses suffered?
After doing the calculation, the loss that I have calculated is euro 28 million.
How did you come to that number?
Well, as I've stated before, my two consideration was IDG shares as its value and IDG shares in their but-for scenario. So what I did was I subtracted IDG shares value from IDG shares under but-for scenario. That's how I reached it.
Thank you, Dr. Williams. No further questions.
That's all.
Before the claimant side does the cross-examination, I'd like to reiterate the time that it is 2 minutes 30 seconds. And furthermore, one thing is to be noted that our session is to be concluded at 12:30. So I believe that we don't have time. They don't have time for closing statement, but we still have time for closing statement. So I think that is something noteworthy. Please go ahead.
I don't think I can deprive any party from making a
Sure, ma'am. Sure, ma'am. That is up to you. Sure.
But please make sure that the cross-examination is within the 2 minutes.
Okay, ma'am.
Madam Chairperson, I'll stick it to under 1.5 minutes and I'll give time for the closing statements. Mr. Causa Williams, in using the DCF approach, which entails forecasting, why have you included the evaluation of Shopup beyond 2018?
Could you please repeat the question?
No, you have included evaluation of the Shopup app using the DCF, discounted cash flow approach, which entails forecasting estimation. Why have you done it beyond 2018?
Let me explain you what DCF actually is. DCF is cash flow.
No, please. I was asking why, knowing fully well that the shop was not performing properly, it was only giving 40%. Why did you, give a what do we call it? You constantly gave a mean sales growth of rate of 6%, knowing fully well that was stuck at 40 and 50%.
your question is right, why I projected the sales growth from 2021 to 2024, right? B1
Yes.
2018. That's what DCF does. Actually, let me make you understand what DCF actually is.
Please
So
be quick. Yes.
what DCF does is it forecasts the future cash flows. You see the monetary values increases. So what we experts do at first, in order to calculate the net present value, that is in 2018, the value of ShopUp. So what we do is we project the cash values from in a projected year in a future, that is from 2021 to 2024 that I've taken.
Yes.
Then after calculating that cash flow in the future, then we introduce a discount rate.
Yes, yes. Mr.
Why is the
Kausa William.
discount rate?
Yes, yes. Sorry for the interruption. Just one last question.
Yeah, sure.
Why did you compare ShopUp with Omega specifically? Why only with Omega? There are many other competing apps. I'm sure Omega is not the only competing app. Why did you only compare it with Omega?
Well, most of the features that Omega app gives is very much similar to ShopUp. That's what I did. Sorry.
Objection, that is a non-leading question from the claimant side.
Yeah, yeah. Apologies. And okay.
We are done with the time. Can we proceed to the closing arguments of the respondent?
Madam Chairman, since both the parties have finished their parts until the arguments and the submissions, aren't both the parties entitled to say something in short regarding their submissions?
Yes. So I will not deprive either party of the closing statement as long as it's to the point and within the time given. And I think we commenced also a few minutes late, so that would be the reason that there is a shortage of timing. So if both parties can please make their closing statements to the point and very quickly, please.
In a very brief manner as much as possible.
Madam, how many minutes should it ideally be?
Well, around 8 minutes, if that is.
Okay, all right, sure, ma'am. Thank you, madam, for giving the floor.
Request for 10 minutes for our closing statements on the claimant side. And I would like to make a point that we do not appreciate taking away our time. Thank you.
No, so both parties will be given equal time, despite the, because both parties, I think, have taken different times and to various arguments. So if the claimant requires 10 minutes, then I will give the 10 minutes for the respondent as well.
Thank you, ma'am. Ma'am, can the council please proceed with the closing statements on the claimants? Ms. Anushka, you have the floor.
Am I audible? Okay. So, good morning, Madam Chairperson. This is Anushka Shikarwar.
I can't hear you very well.
One second. Am I audible now?
A little bit better, but a bit louder, please.
Okay. So, good morning, Madam Chairperson. This is Anushka Shikarwar, counsel for the claimant in this proceeding. I would like to begin with the arguments presented and exchanged, starting with the first and the third issues combined together that we have raised regarding non-performance and fulfillment of contractual obligations. The council humbly contends that there has been a breach of obligations from the respondent's side. IDG Capital has been inconsistent in its behavior while performing the terms of the contract in its essence. Also, it did not perform the kind of duty it was opposed to and the duty to achieve a specific result under the shareholders' agreement. IDG did not follow the time of performance of its obligations either. Also, according to clause 2.3 of the shareholders agreement, the respondent took the sole obligation of completing the full capital contribution of 4 million euros and assumed the firm irrevocable and unconditional intention to disburse the capital contribution stated above and affirmed under clause 2.4 of the shareholders agreement. In the instant case as well, the respondent all of a sudden stopped the disbursement of the capital to the claimant, giving no scope for further negotiations. Further, the respondent gave no responses and did not make the payments corresponding to the third and the fourth capital contributions to the claimant. Therefore, the fact that IDG has been inconsistent and not duty specific is fairly established. as being similarly held in the case of the International Arbitration Court of Chamber of Commerce and Industry of the Russian Federation in a dispute between a Russian company and an American company, where one of the parties, restrained from further negotiations, all of a sudden terminated the contract. The tribunal held that the party should have informed the respondent of its intentions to no longer negotiate to return to the original terms of the agreement. According to the tribunal, the party's behavior was contradictory and inconsistent with the principle of good faith in contractual performance. The respondent have claimed about their fulfillment of the contractual undefined obligation, whereas the council would like to highlight that the approach IDG took for the commercialization was that they would develop and distribute the sustainability of the app, which ultimately they didn't. On the contrary, the respondent failed to commercialize the product with due diligence and effectiveness in the line with annual targets agreed. This is evident from para 10, 13, and 15 of the case facts, wherein the respondent focused on a major online clothing store by the name of Wellis, and failed to expand the business. By the end of 2017, the sales of ShopUp amounted to 250,000 euros, half of the amount estimated in the business plan. By June 2018, the sale results were still unsatisfactory and reached about 40% of the estimate recorded in the business plan. So, in the case Franklin's Private Limited versus Matcash Trading Limited, the Supreme Court of New South Wales held that the recitals to an agreement in certain limited circumstances are a legitimate aid to the construction of operative provisions in the agreement. Taking up the second raised contention on the ground that the exception is not available for the claimants as per them due to the breach of non-compete clause, the respondent have falsely alleged that we have breached the non-compete clause. The council humbly contends that the ShopUp and Omega are two different apps, so the breach of non-compete clause does not arise as per se. At this point, the council would like to attract the attention of the Honorable Tribunal to the matter between Indowine Energy Limited versus Westcare India Limited and another of 2010, wherein it was held that each company is a separate and distinct legal entity, and the mere fact that the two companies have common shareholders or a common board of directors developers would not result in the two being considered as a single entity. The respondent's contention regarding the use of technical know-how by the ShopUp to develop the Omega app is baseless. IDC is unclear as to what technical know-how they imparted. Also, given is the fact that IDG Capital is an investment company and a market strategist, they do not possess any expertise in app development. Again, the market inputs which they allegedly claim we have used to expand the Omega is totally diluted, given the fact that all the modifications and inputs regarding payment gateway were directed towards the specific needs of Welly's online store only, which ultimately lead to the creation of an ad hoc app. At this point, the matter of B. Braun Melsangan, AG and others versus Rishi Bad and others, the court held that the intellectual property can only be claimed on the patented components. If the answer is in the affirmative, then it would be a clear case of infringement and plaintiffs would be entitled for the injunction. Further, minor additions are immaterial. The essential features which collectively amount to an invention are unique and not an overlap of the features of the ShopUp app. So similarly, in the case of Courts Manufacturing Company Limited versus Coloc Manufacturing Company Limited, the court held that the profession, trade, or business activity cannot be restricted on the grounds of few similar ingredients between outcomes. In order to avoid competition, restraint on trade is void. In the instant case, IDG per se didn't pass any technical know-how. In addition to this, nowhere in the agreement or the facts presented, the IDG claimed patent components not to be used. There was no non-disclosure agreement signed between the parties. Further, the mere fact that the ancillary feature of reward points is similar does not render the product competing, and restriction on trade or business cannot be leveled. Therefore, the whole claim of non-compete clause is negated, and claims based on that does not qualify any legal backing. As far as the third issue is concerned, the council would like to merge with the issue of intention as well. So, in totality, the council will summarize and present arguments for gross disparity, intention, and hardship. The council humbly contends that in the instant case, the IDG had taken unfair advantage of the claimant's dependence, economic distress, and urgent needs, or its improvidence, ignorance, and inexperience. The respondent has terminated the contract without consent, despite claimant having been very clear from the beginning about the willingness to continue the contract. Though the claimant, by virtue of unit right principles, would exclude the sale out clause of the shareholders agreement, which gives them an unfair advantage to buy out the claimant shares after invocation of the termination clause at the discounted price, whereas the claimant would like to invoke the buyout provision here. As stated in the Coda versus Carnival Corporation, there exist criteria and presuppositions for the confirmation of disparity. In accordance to the case cited in the present case, not only can the claimant prove the presuppositions alluded to, circumstances have emerged such as not to exclude them in totality. Not only the claimant has succeeded to prove at the time of the non-performance of the contract the fundamental breach of obligations, it was in the state of dependence, economic difficulty, or immediate need, but it has also emerged that it was claimant who was in economic difficulties. The claimant at the time of the contract was concluded was competent, inexperienced, and lacked negotiating skills. In the present case, the claimant has suffered hardship as the non-performance of the breach of the obligations was unforeseeable, cannot be reasonably justified, and the risks were not assumed by the disadvantaged part. In this case, it is the claimant. In the case of Singh versus Carnival Corporation, it is stated that there must exist two presuppositions in order to grave hardship principles to be applicable. That is, there must be a serious disparity between the parties, reciprocal rights and obligations, which gives them excessive advantage to one party, and the excessive advantage must be unjust. That is to say, the one party must have taken an excessive advantages of a dependency. There is a serious disparity between the parties, reciprocal rights and obligations, as respondent did not perform their obligations as they were the funding partner. They were impliedly the first party, which gives them an excessive advantage as they were yet to pay their installments. This led to economic distress, which was unjust. It is stated that there should not exist unequal bargaining power between the parties. Bargaining power is the relative ability of the parties in an argumentative situation to exert influence over each other. In the case of DG Belgrano SA versus Procter and Gamble Argentina, it has been clearly stated that the individual term can be excluded by the mere fact that a party has a greater bargaining power during the negotiation of a contract as respondent had. Does not automatically amount to an abuse of its contractual position. In this regard, the court referred to Article 3.10, now Article 3.2.7 of the Unidroit Principles, which regulates the gross disparity. In the case of Joseph Charles Lemay versus Ukraine, the International Center for Settlement of Investment Disputes, Article 4.1 and 4.3 of the Unidroit Principles 2016 were referred, which talks about interpreting the agreement in accordance with the common intention of the parties, and argued that in addition to the obligations expressly mentioned in the agreement, prior negotiations between the parties should be given emphasis. It is clearly evident that the respondent wanted to escape the contract, whereas the claimant had initiated negotiations, showed the willingness to continue the contract. The respondent themselves in the second issue have considered that the non-performance from their end, which further strengthens our case. In the case of Acme Holding et al. Versus distributor, as regards the amount of compensation due to the distributor for the unlawful termination of the contract, that is termination without the consent of the non-breaching party, the sole arbitrator affirmed that it is a generally accepted principle that in the case of wrongful termination of a contract, damages could be requested to fully compensate the loss arising out of such termination. And in this respect, she quoted Article 7.4.1, 7.4.2, 7.4.3 of the Unidroit Principles. Hence, the distributor could seek indemnification about its losses, damnum emergence, and the gain which it had been deprived of, that is lucrum cessans, provided that both could be established with certainty. I would now like to go with certain rebuttals of some utterly misleading statement made by the respondents. First and foremost, we never used the formulated payment gateway. It was doing fine in the ShopUp too. The tech house are patented by ShopUp Limited. Talking about the difference in the ShopUp and Omega, we developed an entirely different legal entity with different features altogether in the name of Omega. Moreover, Omega was launched on the Play Store, made available worldwide, whereas the ShopUp was restricted to the Asian market only. Coming to the reciprocal rights and obligation, I would like to draw the tribunal's attention to the fact that they were the first party. The respondent was the first party, as the funding party is the first party, as stated in the case of Singh versus Carnival Corporation. Also, the case cited by the respondent, Kohler, specifies that the first party has to fulfill obligations first for the execution of the work as stated by the council. This indeed strengthens our case because the IDG is the first party here, and thereby they have a legal obligations. The fact that they are relying solely on the premise that we never informed IDG before the development of Omega, but the reason why we developed an entirely different app altogether was because the huge amount of profit loss proportion that disheartened us. The council will lastly deal with the issue of damages and relief sought by a client. Mexican Grove versus US distributor, the Centro de Arbitrage de Mexico, the arbitral tribunal awarded compensation for the pecuniary harms, sufficient proof of which was given by the claimant as to amount, certainty, and foreseeability, and its direct connection with the defendant's failure to deliver prescribed by Article 7.4.2, Clause 1, 7.4.3, and 7.4.4 of the Unidroit Principles. The arbitral tribunal also awarded payment of the contractually stipulated penalty for violation of the exclusivity clause. However, since in the case at hand, the precise amount to be paid could not be established with certainty, sufficient degree of certainty of the arbitral tribunal determined it on the discretionary basis according to Article 7.4.3. Clause 3 of the Unidroit Principles. In the instant case, according to the expert opinion submitted by Dr. Elena Blake, ShopUp app competes in the same market as the well-established Omega app. The respondent intentionally insinuated that this comment indicated that the ShopUp app and the Omega app are competing products. The council would like to clear up the confusion once and for all. The existence of similar online platforms in the market is not the same as competing products. Finally, the claimant respectfully requests the arbitral tribunal to issue an award declaring the arbitral tribunal has the jurisdiction to consider the dispute between the parties described herein, declaring the respondents violated its obligation by non-performance, ordering respondents to either perform the signed contract in question or compensate the claimants for the damages and losses suffered as a result of the respondent breaches of contract, currently estimated to be in 6 million euros, and declaring that the clause 15.2 of the shareholders agreement is liable to be invoked in the claimants by the claimants as to facilitate the acquisition of ShopUp from the IDG Capital. That's it. Thank you very much, Madam Chairperson.
Madam, it is to be noted that our learned friend from the claimant side has taken 14 minutes. So it is requested to this honorable arbitral tribunal so that we are also granted 14 minutes to make the closing statement. Otherwise, it would be favoring them more than us.
Can somebody confirm that timing? Besides, sorry, I missed the timing. Can somebody else confirm that it was 14 minutes?
It was 13 minutes as per us.
Anyone else from the other side? I don't want to be unfair, but they're racing on time and need to be on point.
That's fine, ma'am. As long as
if you can finish your statement in 10 minutes, but if you do want to proceed, let me come on.
Great. Thank you, madam. Thank you very much, madam, for giving me the floor. I am the respondent counsel representing IDG Capital in this case, and I shall be doing the closing statement. Madam, I shall be very briefly giving some refutations to some of the points they made and hammering on some of the legal arguments that we have submitted so far. To begin with, madam, the first thing that the council will address is that IDG Capital had fulfilled all of its obligations under the shareholders agreement up to the point of breach of contract. This argument has two limbs. The first is that capital contributions were made duly prior to the breach of contract by the claimants. Madam, we all are clear on the overall facts that for the capital contribution was to be paid in 4 installments. The first 2 were paid, the latter 2 were not paid. What our learned friends from the claimant side are arguing is that it led to a non-performance on part of IDG Capital. However, that is not true because there is a clear justification for the non-payment of capital contributions of the latter 2 part. And what is that justification? Madam, as per Article 7.3.1 of the Unidroit Principles, when a party fails to perform its obligation and it amounts to a fundamental non-performance, the other party may terminate the contract. Indeed, when ShopUp and the founding partners developed Omega app, which had very similar features as well as the same customer pools and had a renewed online payment system, as it was proved in the cross-examination and the chief examination from our side, we have seen that they had fundamentally breached the contract, and that gave rise to a right to terminate the contract to IDG Capital. So how did IDG Capital exercise that right to contract? That is the question now. IDG Capital, right after the day when Omega app was released on market in 1st December 2018, they on 2nd December 2018 sent an email to them expressing their discontent and that they no longer wish to be bound by the by the provisions of shareholders agreement. Indeed, the respondent's email on that particular date, 2nd December, amounted to a notice served to terminate the shareholders agreement. If you look at the definition of notice, we'll see in Article 1.10 of the Unit Right Principles that a notice includes a termination, notice includes a declaration, demand, request, or any other communication of intention. Indeed, the email that was sent on 2nd December was a communication of intention that IDG Capital no longer wanted to be bound by the provisions of the shareholders agreement. The consequence of that termination is that it released both the parties, ShopUp, founding partners, and IDG Capital from their obligations to effect and to receive future performance. That is to say, both the parties were no longer obliged by the shareholders agreement. So even if the two payments were due, by virtue of the fact that the contract was terminated, IDG Capital no longer owed the two installments to ShopUp and the founding partners. The second limb of this argument is that the target sales were not reached due to the fault of ShopUp and the founding partners themselves, and not because of IDG Capital. It has been reiterated from time to time and again by our learned friends from the claimant side that IDG Capital, it was IDG Capital's marketing strategy flaw or fault that led to their demise. However, that is not true. Why not? The key case is Collar versus Khan Industries Limited. As my co-counsel Fardin Fayaz has already mentioned this case before, and I reiterate, the facts of this case is very similar to the case that we have at hand today. In the given case, Collar versus Khan Industries Limited, the respondent was provided with defective products by the claimants, which could not be marketed, and therefore the respondent could not pay commission to the employees of the claimant side. And the court stood with the respondent side, stating that the products were defective and therefore it could not be marketed, and hence the respondent had suffered loss. The situation is very similar to what we have today in this particular case. If ShopUp had a marketable product with good features, with fully functional features, including the online payment gateway system, then IDG Capital could have fulfilled its obligation, that is, reach the target sales amount. However, because the product was faulty to begin with, it could not be marketed on a wider scale, hence it was off the mark. So this fault is attributable to them, not to IDG Capital. Madam, with that, the first issue, which is that the respondent has fulfilled all of its obligations under the agreement up to the point of breach of the claimants, has been established. Now, on to the next issue. It is humbly submitted before this arbitral tribunal that the respondent did not commit any gross disparity, as alleged by our learned friends from the claimant side. They have, from time and again, argued that the claimant that IDG Capital committed gross disparity by taking unjust advantage of the founding partners' weak position in the sense that they were inexperienced and it led to hardships. Now, there are two limbs to this. First of all, what they're saying is that there was unjust advantage, and second of all, it led to hardship. But the thing to note here is that gross disparity or any sort of unjust advantage is not clear from the facts at all. Nothing has been stated in any of the email correspondences between IDG Capital and ShopUp that they were they faced some sort of hardship, economic hardship and whatnot. Whatever hardship arose was after the capital contributions were paid. What is to be noted, madam, is that the hardship they faced, if that is true, was faced after the stoppage of capital payments. And stoppage of capital payments clearly had a justification because IDG Capital had already terminated the contract. They were no longer bound to pay the rest of the two capital contributions. Therefore, Whatever hardship they faced after that is up to them. That is not the concern of IDG Capital anymore, because the shareholders agreement is no longer standing. Second of all, they cannot, our learned friends cannot bring up the argument of inexperience, that they were inexperienced, that ShopUp was inexperienced in the business realm, that they were taken advantage of. On a legal point of view, we have to look at the new lex marketoria. The new lex marketoria, in the new lex marketoria, there is a presumption of the professional competence of the parties to an international commercial contract. Note that the contract we have at hand, the shareholders agreement, was an international commercial contract. The parties may therefore not argue that they were unaware of the significance of contractual obligations to which they have agreed. If I were to cite an authority on this, ICC award number 2291, in that particular case, the arbitrator refers to the presumption of professional competence with respect to the party's duty to observe a normal, useful, and rational degree of care in the protection of their interests. It has already been established during the cross-examination of Roshni Bose that ShopUp was already established in Bangladesh, and it was also operating in India, which means it is a startup company that was operating internationally. So it can be safely presumed that the claimants knew exactly what they were signing. If they argue inexperience, it cannot be an excuse to signing the contract because of the presumption of professional competence of international businessmen in an international commercial contract. Inexperience cannot be an excuse to signing an international commercial contract where the parties are usually keen bargainers. Therefore, this argument does not stand. And it has already been proven that the hardship that they faced, nothing about any of the hardship that they faced was ever brought up in any of the email correspondence, first of all. And second of all, they never, whatever hardship they faced, if that is true, that is after the capital payments were stopped, and the capital payments were stopped for a justified reason, and therefore it is not the concern of IDG Capital anymore. Moving on to the last issue that the respondent counsel would like to humbly submit before this arbitrary tribunal, and that is that harm has been suffered by the respondents, and that such harm was foreseeable, and therefore damages are sought. We have seen from the chief examination of Dr. Kausar Williams, witness number 2 of the respondent side, that the losses suffered by IDG Capital amounted to an astounding 28,203,925 pounds. There's an astounding amount, madam, and this amount is not the actual loss suffered, rather it is the future gains that the respondent IDG Capital was deprived of. Harm, according to Article 7.4.2 of the Unidroit Principles, means that any loss which a party has suffered or any gain of which it was deprived of. Here, IDG Capital, because the contract was breached by the claimant side, it led to IDG Capital being deprived from the future gains it was supposed to make on the investment it made on ShopUp. And therefore, this loss should be the amount that should be indemnified to IDG Capital. As per Article 7.4.4, damages must have been foreseeable or reasonably foreseeable by the breaching party to be liable for the damages. As per the English case of Hadley versus Baxendale, the House of Lords defined foreseeable losses as any losses that may fairly and reasonably be considered as arising naturally, that is according to the normal course of things. Indeed, in this case, the claimants must have surely known that if they breach the non-compete clause, it would diminish the value of ShopUp, and that would have an impact on the future profits to be made by IDG Capital. Thereby, since the losses were foreseeable, reasonably foreseeable by ShopUp, IDG Capital is entitled to compensation. With that, the arguments and the refutation has been dealt with. Madam, if the council has your permission, the council would like to move on to the request for findings. Very briefly for 30 seconds.
How long is that? Because your minutes, I think, the 30 minutes.
30 seconds, ma'am. 30 seconds to 1 minute. It won't take too long. Madam, based on the legal principles and the legal precedents and the principles cited, and in light of the provisions of the national and international laws, as well as the arguments advanced, the respondent most humbly prays before this arbitral tribunal for the following remedies from BIAC arbitral tribunal. 1. Declare that the arbitral tribunal has jurisdiction. 2. Order the claimants to pay a compensation of 4 million euros as the liability cap has not been removed by any of the parties. However, if the tribunal deems fit in the light of equity, it is also paid to the tribunal to order the remaining losses of IDG capital, which amounts to about 24 million euros, as noted by Dr. Kausar Williams. Thirdly, declare that the claimants have breached the non-complete clause and therefore triggers the buyout provision of clause 15 of the shareholders agreement. 4. Declare that the claimants acted in bad faith in the course of their dealings with the respondents. 5. Declare that the respondents performed all of their obligations up to the point of breach of contract by the claimants. 6. Declare that there is no gross disparity committed by the respondent. And 7. Declare the respondent, as per the financial report of Dr. Kausar Williams, is entitled to buy the founding partner shares at a discount of 30%, that is 3.8 million, or sell its shares to the founding partners with an increase of 30%, euro 2.4 million. With that, Madam, the council would like to humbly conclude his submissions. Thank you very much.
Thank you very much. Mr. Azad, would you like to give feedback now, or is there anything else that wants to?
Ma'am, I think the claimants are okay with whatever you decide.
Yes, madam. Same from the respondent side.
Madam Haida, I would like to request you to sum up, and in the meantime, if you process the results, we'll be privileged to have a copy of it, and later you will declare the results officially.
Okay, so I'll give you the feedback now, and you need to give me about 5 minutes to sort of consolidate the marks that I have given you. So I must congratulate both teams, or both did very well, and it has been extremely difficult for me to decide who is better than the other, and even if there is a winner, it will be on a very small margin, because you all had equal plus points, and if at all there were some deficiencies, both sides had those deficiencies. So I will just explain to you my comments. So basically, your preparatory notes and the written information that you have provided was very good, very detailed, and I appreciate that, and that's a good beginning. But however, what I noticed throughout, and you may have ascertained that my questioning was to understand that, was to see whether both parties had understood the case very well. Because in this kind of competition, and even as a law student, which I assume you all are, you tend to come up with your own views on things, and bring in a lot of case law, a lot of principles, a lot of statutes, without actually focusing on the actual dispute. So this is where I think both of you had got a bit sort of derailed, because you all have got into the whole thing about proving in cases and principles, that you all had missed a few simple points. So basically, from what I understood is that, I mean, I haven't read as detailed as you all have, but from the bit I read, the breach, there is a breach due to and the breach is because of a non-competition, breach of a non-competition clause, because one party says they were not required to perform the contract because one party was in breach. That clause itself is very, very broad. I actually looked at it about 3 times to see whether I'm missing something, because that clause is very broad and gave you all enough of ability to argue on that point. And neither of you really went into that, except I think one party towards the latter part, I think the closing statement mentioned it, but that was not given enough consideration. So always look at the practical sides of it as well. We have the law, we have rules, we have various statutes to help us, but it must stem from the practical issue in hand and the practical way of dealing with it. So I think both sides could have improved on actually dealing with that topic, which was given on a silver platter to you, because it was a very broad clause for both sides. one to argue that there was a breach, the other to argue that there was no breach. Because there was no reference to apps there was no reference to any particular type of business. So it was not a very detailed non-competition clause. So both parties should have taken that more into consideration. Argument-wise, very good. Even the opening statements are very good, but again, you need to be on point, because one thing you have to keep in mind, even in a competition or even in a real arbitration, is that the arbitrators are all supposed to be experienced people. So they are aware of provisions of the unit law, they are aware of the rules very well. So you don't need to repeat those things. They all they want to know is the facts and how the facts relate to the case. And you have given them material to go through on reference, so you don't have to say that again, because then it sort of dilutes everything that you want to say. Okay, so be careful about that both sides in the future. Then on the witnesses, I mean, I think the witnesses could have been prepped a little bit more. The witnesses were not convincing. Because in a clause, in a competition of this nature, those are the things that will get the interest of the judge. Whether the witness is confident, whether the process, and particularly the examination. I must say the cross-examination, both sides did very well. And I commend both sides for that. But the examination per se, both sides were fairly low-key and very, not very convincing. If I was an actual arbitrator, I would have asked more questions, but there was not enough time. So you need to be very strong. You need to prep your witness before. And I also saw you're tending to agree. The counsel examining the witness is tending to agree with the witness's response. Now that is a real no-no, because I mean that means the witness is not independent. Okay, so you can't agree. You can't ask a question and then when he gives an answer, says yes, I agree with that. No. That's a very good answer. I mean those things are completely a no-no for you to remember in the future. So other than that, I don't have anything to say except stick to the timeline and be nice when you're referring to the other side not complying with the timeline, because those also set impressions in the arbitrator's mind as to you're trying to get some advantage other than to your argument. So you have to be careful when you address shortcomings from your opponent. It's always nice to be, when you're nice to your opponent, it's always better. Okay. And ask in a nice way. If the opponent has taken a little more time, may I also have that time? So I'm just giving you all points so that you go ahead further in this competition. Subject to that, is there anything that you all want to ask me before I go back to finalizing the results?
I did have a doubt, ma'am, if I may ask. Ma'am, you said that the non-compete clause was very wide. How could we have taken advantage of this?
Yeah, so let me get the clause in front of me so that I can. Yeah, so it says agree that the capital contribution is corresponding benefit and goodwill of the company as it exists on the closing date. So you all didn't, no one spoke about the goodwill. Did I ask? So the claimant should have said there was no impact on the goodwill. If at all, there was more goodwill through, even though it was a different entity. The respondent should have gone on the fact that they have actually moved it to this other company and not brought in that goodwill into the entity, because the entity is an investor. It's not really involved in the business per se. So you could have gone on the goodwill component. Then business will not be diminished by the acts of the company and the founding partners. So basically, again, the claimant could have said there was no breach because the business was not diminished. It's only because the other side didn't have the distribution network ready and things like that, and the fact that they changed the specifications and things like that. Then directly, indirectly, the A subclause talks about a competing organization. Now, the whole argument was that they themselves developed this app for themselves. So you could have argued, I mean, the claimant could have argued that there was no competing organization that they provided the services to, that this is something that usually when you draft a non-competition clause, it's a bit wide and more specific. You refer to a business, particularly in this tech-related contracts. You have to describe the business, like development of an app for lifestyle or whatever the app features, and say you cannot do that anywhere, develop a similar app for another party. Now, none of that is there in this clause. So both parties should have capitalized on this. Anything else? Generally, in tech contracts are very, very careful as to what to prevent the other side from doing business. A clause like this will them anyway.
Very watertight contracts.
Correct. So basically, watertight clauses where you describe the app, you describe whatever model, like platform the app is on, and then prevent either party from using any of that. Then they would have been in actual breach because it's another app doing probably something.
Right.
But here it's arguable, and I think that's the way the case is structured to give you all the opportunity to argue.
Thank you, ma'am. I do not have any further questions from my side.
Anything else?
If it is okay, madam, with your permission, let us take a break. You prepare the results.
Yes, it's going to be a very difficult task.
Yeah, on to our General Manager, Mahbubur Rahman.
Dear all, it will take 5 to 7 minutes to prepare our result. During this period, we will watch a video on introducing BIAC. Dear all, we need few more minutes to announce our result. We can take a short break for 5 minutes. Please do not sign out from the session, but you can keep the video and audio turned off.
Okay, ma'am. Thank you. So hello from the other side. Guys, we can speak here, I guess, while we wait. No takers, really?
Hello there. Hi.
Hello. Yeah, it's been fun, right?
It was. No hard
It was fun.
feelings, man.
No. This is a competition. We are talking outside of this competition, right? We're different people when we are outside of this competition.
Outside the competition, I am liaising between the two participating contestants. You can talk among yourselves.
Thank
Yeah,
you,
right.
sir.
Yeah. Thank you, sir. This was fun. So I am in Kolkata. You guys are all in Bangladesh, yeah?
Yeah, all in Bangladesh.
Right. This was fun. This was the first time we participated in international arbitration, in any arbitration, really. So yeah, it was a very enriching experience.
I do have a question though. If you're all in different places, how did you coordinate?
No, see, we are in BSNLU Vizag, right? Andhra Pradesh, but we are having online classes. So we are used to online classes for the last 1.5 years. So yeah, Zoom is everywhere.
True.
সবাই জুমে কথা বলতেই পারে, কোনো অসুবিধা নেই তাদের।
Oh my God. Yeah, that's great. I mean, we felt like you guys were excellent in everything that you conducted, the opening.
Same here. Extremely professional.
Yeah.
Thank you for competing with us. I hope one of us is going to be the winners, but whoever isn't the winner, I don't think we are really losers at the end of the day. We've learned a lot.
Exactly.
I really liked all of the counsels that came from your side, to be honest. It was very fun. Especially the cross. I got scared.
No. I think cross examination, it depends on what's happening in the proceedings, right? We can't really, take the questions from beforehand. We have to decide then in the spot. Like we had some questions in our mind, but we had to formulate the questions according to your proceedings, right? So yeah.
I think your cross examiner did an excellent job. Like the questions asked, there was, the drive to it. It was good. We noticed that.
Yes, Rafi dada dhanyawad.
কোথায় সিদ্ধার্থ কোথায়? এই তো
আমি জনসন দাদাকে একটু সরি বলে দিই। সরি। You all speak Bengali, right?
Yeah, we all speak Bengali.
আমার সবাই তো বাঙালি।
আচ্ছা,
আমাদের টিভি সবাই বাঙালি।
I don't speak Bengali na.
ঠিক আছে।
Yeah, people from Goa and Uttar Pradesh are unlikely to follow Bengali.
Yes, sir.
Amazing experience. Like I was thinking that I'm going to choke up, but thankfully I didn't stammer and stutter. I generally do stammer and stutter in front of people, but thankfully I didn't this time.
Yeah, it's all part of the experience. It's like the first time we are doing, I am doing first time. So really,
I think it's first time for all of us from our side.
Yes.
It's also first time it is a privilege to have international participants in such a mock arbitration hosted by BIAC.
It's a privilege for us to participate also, sir.
Yes, sir.
It's an honor. Thank you for selecting us, because we thought there were going to be other applications from all over India, and we thought we won't be selected, but here we are.
There were from these other countries and also from Bangladesh, and we picked up on merit, actually.
Okay.
And I'm amazed that you have picked up at least people from 4 states of India and 5 cities. It's quite interesting.
Thank you.
Yeah. In our university, we have people from all over the country. So we've been coordinating online for the last 1.5 years, as I said. And this was nothing other than an online class for us, if like for lack of a better comparison.
It felt like that, an online class.
Yeah,
Online
it felt
class
like
and
that.
actual participation.
It was actual participation.
It would have been fun if this was in person, though. So we would have got our
gotten our passports much more different.
Yeah. And we would have come to your country.
Platform, even on this online platform, we coordinated well between us. But if it had been in physical, then coordination will be much better.
Yeah, coordination would have been much better. The experience would have been more realistic, and we would have gotten to visit Bangladesh.
Of course,
that's a big thing for me. So my family, my father's side of my family is from Bangladesh only. So we used to live in Faridpur, and then we came across after after 1947.
Yeah, Faridpur is close to my hometown. It's Noakhali, so not too far away from my place. Yeah.
My grandma's family is from Noakhali.
Oh, okay. That's interesting.
Right.
That's
yeah.
interesting. We have another. We also have Maimuna Chaudhary. She's also from Noakhali, isn't it?
I'm laughing because of like the the whole characterization Noakhalians have towards the rest of Bangladesh. For the others who don't really know, there's a lot of controversy regarding Noakhalians, especially in the country.
Like what?
Certain habits in comparison to other districts and things like that.
Okay.
It's a joke that's like taken, that's discussed when Noakhalians are like brought up in any sort of conversation.
Right. I see. You know, the main difference that I see is basically the difference in dialect. Right, the Bengali I speak Ghoti Bangali, right? I'm a Ghoti Bangali. But the Bangal Bhasha that you guys speak, that's I think, in my opinion, far more attractive, the accent. Right? Yeah, because everybody in my home, they speak in Bangal only. They don't speak in Ghoti. Right? So I get all of it. I speak a little bit of it, but I can't really do justice by speaking it, you know?
Just the point of, I just wanted to know, all the respondents, which year are you from?
Oh, like we are mostly from 5th year. I mean third year.
Third year, and we have one first-year student with us.
One first-year student. That was Jon Snow, by the way. He did pretty good for a first year.
And Jon Snow lifts.
So we are ranging from 1st to 3rd, 5th. So it's a whole range.
Okay.
Okay. Right.
All of us, we are in 2nd year. We are in the same
As
section.
India is a multicultural and multilingual country.
Yes,
may I ask Joshi a question? Can you speak a bit of Portuguese, Joshi?
No, I cannot.
From Goa?
No, I cannot. I'm sorry, I cannot.
Okay. But I add Vasco da Gama in my bucket list. Must I not miss during my next stint around?
I am invited, sir.
Thank you.
So from this experience, I think like most of you are going to come for future arbitration competitions as well.
Of course.
So it would be nice if we could all meet like on a later date, probably.
For real?
For real. It would be nice.
Absolutely. Let the world open up first, right?
Yeah. True.
The world is closed.
I actually attended a mediation competition based in Kolkata. It was in NUJS. I don't know if you guys participated as well. It was during the start of, last year, just before COVID.
Okay.
So you guys actually come here? Yeah. I was in Kolkata.
What was your experience of Kolkata?
I mean, I went to Kolkata plenty of times before. That was like the 6th or 7th times. So I'm very familiar, around Kolkata.
It's a nice place, but to be very honest, Kolkata is somewhere you retire, not start your career.
Yeah.
Right? People come here to retire because it used to be a very nice place, in very nice city. It's getting developed little by little now, but mostly there is a lot of slack in the government, right? So people here are ঠিক আছে যেটা হচ্ছে হোক পরে দেখা যাবে. This ladkhore people are there in Bengal.
When she'll become
now we are expecting the result.
Excuse me, dear all.
Yes,
our result is ready. I would like to request our chairperson of the session to declare today's result.
Okay, so sorry. Sorry, I took a little more time because I had to evaluate and reevaluate because, as I told you, the difference is very, very small. So unfortunately, the claimant has got 71 points and the respondent has got 72 points. So the respondent has won the arbitration only by the presentation of its to the witnesses. This is where I have shared the score sheet, which I'm sure the BIAC will share with you. So it was only on that ground. So your technicality and your hard work, don't get disheartened. This is only a competition and very little can change between arguments and from what I have seen, all the teams have prepared very well, and each of you performed in your own way and have done your own research. And particularly in an online atmosphere, I'm aware of the difficulties in preparing. So the product was very, very good from both sides, I must say. And you will know from the scoring there you have altered, and that's only for the benefit of doing better the next time. So congratulations to both teams.
Can you please name the party, the respondent who has won?
It's the Bangladesh system. Sorry, very bad. So it's a London College of Legal Studies, South Bangladesh, that has won by 1 point. Thank you very much, and I hope the claimants or the Indian university is not disappointed, but you did very well. So congratulations on that.
It was an enriching experience, ma'am.
Definitely. And it was
Just remember next time, prepare a witness a little bit.
Honestly, I wouldn't have minded even if we had
It
lost.
has been a very close contest. I welcome
Honestly,
both the
yeah.
parties for their
And
participation.
it's only because the scoring requires you to score on witnesses. If it was only on arguments, it may have been different.
Is there no way there can be a tie?
Yeah, unfortunately. Yes. Okay.
Look forward to your
But
participation.
honestly, this is this is a very enriching experience, and for the first time in my life, I am not actually disappointed that I lost. Very enriching experience. Thank you everybody who's here. Thank you, ma'am, so much for asking us the right questions and guiding us towards the correct path. Thank you so much, ma'am.
All the very best. And please feel free. I mean, Mr. Azad has my contact details. If there's anything or any from Sri Lanka, please let me know, because you are all very competent. You are very good lawyers and arbitrators in the future. All the best.
Thank you, ma'am.
I'd just like to add that we are, from the respondent side, we are in ICLP South. We're extremely honored to face such a, formidable team from India, an international team on an international competition. And this was truly an honor for us. And as Pranesh has said, this was a very enriching experience. So thank you guys from DSNLU. And thank you, madam, for guiding us through the arbitration.
It was a pleasure.
Congratulations to the team of London College of Legal Studies, ICLP South. And thank you to the team of Damodaram Sanjivayya National Law University, India. You guys did a very good job. Better luck next time. I would like to request all participants and our chairpersons to open their video for capturing a photograph. Thank you all. I would like to conclude the session by thanking the chairperson of today's session and team members of the Damodaram Sanjivayya National Law University, India, and the London College of Legal Studies, along with their faculty members who worked hard to train up and prepare their students for this contest.
Thank you, ma'am. It was an honor for us to be here.
Before concluding, I would like to invite you all to our second session of preliminary round, which is to be held on 8th November at 10 a.m. BST between Bhuya Academy, Bangladesh and Lahore University of Management and Sciences, Pakistan. I'm Mahbuba Rahman Runa, General Manager of BIAC, was your host and coordinator of this contest. Thank you all for joining us online. Thank you all once again. Allah Hafiz.
Thank you for the invitation and all the best to all.
Ma'am, are we free to leave this meet?
Thanks, guys. Take care, everyone.
Same for you guys.
Thank you all. Thank you all. Goodbye.
Thank you, ma'am. Goodbye.
Thank you all. Thank you.